morning, Chair.
Thank you. Good morning, Ms. Kwinana. Okay. Are we ready?
We are indeed.
Okay. Please administer the oath again, affirmation.
Please state your full names for the record.
Yakhe Kwinana.
Do you have any objection to taking the prescribed oath?
No.
Do you consider the oath to be binding on your conscience?
Yes.
Do you swear that the evidence will give it be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Good morning, Ms. Kwinana.
Good morning, Advocate.
Ms. Kwinana, I would like to start today, if we may, by just going back for a moment to the decision that the board took to award the components tender to the joint venture of AAR and JM Aviation. You'll recall in your evidence on Tuesday, your attention had been drawn to the fact that they actually should have been disqualified from the bid. And in fairness to you, Ms. Kwinana, you conceded in the end that they ought not then to have proceeded, and if that had been known to you at the time, you accepted that they couldn't have been awarded the tender. What I didn't traverse with you was the board's actual decision at the time to award the contract to the joint venture of AAR and JM Aviation. And so I would like to just deal with that briefly, because I just want to explain why. As I understand your evidence, at the time, you had no idea about the fact of the communications that they'd had with Ms. Mamela, and so you didn't know that they ought to have been disqualified. Is that correct?
Yes, Chair.
So I'd like to go to the reasons the board gave for actually approving their appointment for the contract. And we need to go there because what had happened was you had got a recommendation, hadn't you, from the acting CEO, which was not to award the contract to AAR and JM Aviation. It was to award the contract to Air France. Is that correct?
Sorry, I can hardly hear you. Can someone reduce the...
Oh, the aircon.
Yes, please.
Yes, okay. Yeah, they will attend to that. Yeah, sometimes it makes it difficult to hear people.
Sorry, can you repeat your question, Chair?
Certainly. So...
Just maybe don't switch it off completely in case it becomes too hot, but, let it be low. Yeah.
Is that clearer for you, Ms. Kwinana?
Not the aircon, Chair, but the sound.
You need the sound a bit louder, do you?
No, the sound is a bit higher.
Oh, too loud.
Too high.
Okay.
Yes. It seems as if it has got an echo, Chair. Yeah, echo. Yes.
Okay.
Is this a bit better? Can you hear me better now?
Yes.
Okay.
Okay.
I'll also try and drop my voice maybe a bit.
Not too much.
Not too much, no, indeed, because I have to reach it there. And so, Ms. Kwinana, what I was just confirming with you was the decision was taken, as I understand it, on the 9th of May 2016. Does that accord with your memory?
Yes.
Right. And what happened is, before you at that board meeting, as I understand it, you had a BAC recommendation. You had a recommendation from the acting CEO, and by that stage, their combined recommendation was that the contract should go to Air France, correct?
Yes, Chair.
If you'll just speak a little bit louder so that the...
And remember to look this side.
So they were recommending Air France, but in that meeting on the 9th of May 2016, the board decided, and we'll get to the reasons in a moment, to award it to AAR and JM Aviation, correct?
Yes, Chair.
Now, Ms. Mamela testified previously, and I just want to check that you can confirm this part of her evidence. When those submissions come to the board, you don't get all of the bid documentation or anything like that, do you?
Yes, Chair, we don't.
So you've really just got the submissions, and is that all?
Yeah.
Yes.
Submissions.
Okay, so you've got the BAC recommendation, you've got the acting CEO's recommendation, and at this meeting you decide to not go in accordance with their recommendation, but to go for AAR and JM Aviation. Can you explain to us why the board took that decision?
The reasons, Chair, in fact, Air France was number 3. Lufthansa was number 1. And AAR was number 2. And then there was a recommendation of number 3. Now, we asked questions as to why not number 1. And management gave reasons for not selecting number 1. And then we asked, why not number 2? Why are you jumping to number 2? And
To
then,
number 3.
To number 3, yes. And then they stated the reasons, which basically were not acceptable to the board. If, from top of my head, without looking at the minutes, but one of the reasons was that AAR never did business at SAA, and therefore they do not know SAA. And we said, then if that was one of the criteria, they should have said it from the beginning when the tender was going out. So we rejected that reason. And then the other reason was that AAR had a lower price, much lower price compared to Air France. And then there was a concern that AAR may be lowballing. And then the board requested for a mitigation to say, is there a mitigation if, for instance, they are lowballing? Can't we fix the price? And then we said, then this should be awarded to AAR, subject to them fixing the prices if that is the lowballing. And we gave it back to management. That was the reason, basically, why AAR was selected. But maybe I need to go back to what we talked about in respect of the proposal, the attachment of the proposal that was sent to Ms. Memel. And I had an opportunity of, again, reading the transcript of what was the reasoning for Mrs. Memel. And the reason for Mrs. Memel basically was that, or in fact, I don't even have to state her reasons again, but she said she is not part of the cross-functional team, and therefore there is no way that she should have seen the line in the tender document that says bidders can only conduct the project manager. And therefore, because that is not a policy, an SAA policy, it is a policy within a specific set of people, which is the cross-functional team. So basically, as I was saying, it would depend on the circumstances. Thank you, Chair.
Ms. Kwinana, that is again a reversion to a version that you gave on Tuesday, that we'd moved past. You'd given your fair concession that it shouldn't have been awarded in the circumstances. I'm not going to go back to that. I'm interested in the decision for which you were responsible, which was the board's decision. So let's go to the minutes of the meeting, if we may. For that purpose, you'll need bundle DD 22F. Just going to ask my colleague to assist you. F, yes, and we'll be opening it at page 2304. Correct. And Ms. Mbanjwa, it will be page 2304. Ms. Kwinana, do you have that?
Yes, Chair.
And Ms. Mbanjwa, have you got it? Okay. So, Ms. Kwinana, this is minutes of the special meeting of the South African Airways Technical SOC Limited Board of Directors, 2016-03, held on Monday, 9 May 2016 at 8:30. And in attendance, it seems to indicate that you were present. Can you confirm that you were present at this meeting?
Yes, Chair.
And then if you go over from that first page to page 2305, you'll see there's an item there under 4, matters for consideration or approval. Do you see that?
Yes, Chair.
Now, that is where the issue of the awarding of the components contract was dealt with. And I would just like to read into the record, also for your benefit, to refresh your memory, what is minuted here as being the basis for the board's decision. It reads as follows: the submission was tabled and considered. According to the submission, management recommended that the tender be awarded to Air France. A discussion on the matter ensued, and the board made the following comments. A, management's rationale for recommendations that Air France be awarded the tender was not substantive. Considering the bidder's resistance to align itself to SART's developmental agenda, i.e. supplier development. Furthermore, the benefits outlined by the submission as a result of selecting Air France were not compelling enough to position the latter as the preferred bidder. And then it goes on, the concerns regarding JMAAR, especially management's view that this bidder was low-balling, could be mitigated by reducing each party's obligations as well as terms and conditions to writing. And then the resolution is recorded, resolved that the request for the approval of the award of a tender for the aircraft component support and services on ATA chapter for both the Boeing and Airbus fleet for a period of 5 years to JMAARB and is hereby approved, subject to the mitigation of all the risks highlighted in the submission. So I'd like to focus just on one or two aspects there. As I read this recordal, one of the reasons for not going with management's proposal is reflected there as Air France's resistance to aligning itself to SART's developmental agenda, i.e. supplier development. What was that reason based on, Ms. Kwinana?
One of the criteria, Chair, was that the bidders should comply with BEE, and therefore, basically, Air France, in fact, should not even have been there because they did not have the BEE. So basically, Air France was not even supposed to be here.
What does have BEE mean?
Like to be BEE compliant.
Yes, that was a requirement of the tender. They were BEE compliant.
Yes.
So how could you possibly have rejected them on the basis that they didn't have the requisite BEE status?
That was the critical criteria, Chair.
Yes. So they couldn't have...
I'm not sure if you are not speaking at cross purposes. You said, Ms. Kwinana, that you rejected the recommendation that Air France be awarded the tender because they did not have effectively BEE credentials which were required. And then Ms. Hofmeyer said to you, but what does that mean? And I think you agreed that it means it relates to being BEE compliant. So she says to you, but they were BEE compliant, so what were you talking about? That's where she is. So how could you reject them on the basis that they were not BEE compliant when in fact they were BEE compliant?
Chair, my understanding, also according to this, is because they were not BE compliant. So if, for instance, they were BE compliant, then I would have to go further and check what score did they get in respect of BEE. And secondly, Chair, that was not the only reason why France was not selected.
Okay,
France was in
before we
fact
go
number
to
3.
other reasons, let's just make sure we are all on the same page on this one. So if it can be shown that they were BEE compliant, would you accept that the reason reflected here as the reason why the board rejected them, or the reason which you gave that they were not BE compliant would therefore not be applicable,
Yes,
if
Chair.
in fact they were compliant?
Yes, Chair.
Okay, all right, Ms. Hofmeyr.
Thank you, Chair. The reason why I asked you what does weren't BEE mean is because the way that requirement played out in this tender was in a particular way that we spent some time traversing in Ms. Mamela's evidence. But what you did have before you was the CEO's submission, which gave you a summary of the rankings of the bidders on this aspect, right?
Yes.
And I'd like to take you to that for a moment, because it's just further back in the bundle you have, DD22F, and we just need to go back to page 2274. Do you see that?
Yes, Chair.
Now that is the acting CEO of SART's recommendation to the SART board dated 26 April 2016. And this is where the recommendation is made that Air France Industries be awarded the tender. I'd like to take you to what was recorded there as the rankings on price and BEE evaluation for the tenderers, and you'll find that at page 2280. As I understood your evidence a moment ago, Ms. Kwinana, sorry, you were getting there. You said Air France was not BEE compliant, and so they shouldn't have even proceeded through the tender process. Is that right?
Yes, Chair.
Yes, that was your understanding at the time.
Yes, Chair.
If that was so, if other tenderers were not BEE compliant, they shouldn't have been awarded the tender either, should they?
What they did here, Chair, putting the price at 90% and BEE 10%, they are 100% correct. And now, considering that all of them were not BEE compliant, that's fine. They did not get the scoring for that. Then now, they would have to be scored on other things, on the 90%. Being technical and price or something like that.
Indeed. So BEE could never be a reason to choose one over the other of these suppliers, could it?
Yes, Chair.
But the board gave that as one of its key reasons. That was irregular, wasn't it?
Chair, if that was a critical criteria, that means if they all do not meet the requirement, and if it is a critical criteria, then we need to check if the BEE was a critical criteria. So can you check that for me, Chair?
No, Ms. Kwinana, you see, I'm working just with the board's own reasons. The board's own reason, which we looked at a moment ago, is that despite management and the bid adjudication committee coming to the board of SART and saying Air France should get this tender, The board did not go with that recommendation. And the recorded reason is because Air France had resistance to align itself with SART's developmental agenda, i.e. supplier development. So I began by asking you, what was underpinning that reason? And your testimony this morning is Air France wasn't BEE compliant, so they shouldn't have even progressed in the tender process. Ms. Kwinana, you've now been shown that none of these tenderers were BEE compliant. We've now seen that at page 2280. I am saying that quickly because there's another explanation I'm coming to, but this is what's before you. So I put it to you, you cannot possibly then reject management and the BAC's recommendation for Air France, not select them, select AAR and JM Aviation when none of these parties were BEE compliant. How could that be a reasonable decision to make?
Chair, that was not the only reason. Air France was number 3, that is number 1. And secondly, when management comes and make a recommendation to the board do not just rubber stamp and say now management, otherwise there would be no reason for management to recommend anything to the board. And therefore, I am confident as I am sitting here that whatever was discussed there, which basically is not the only thing that was discussed that is in the minutes. If you have got a recording of that, I would very much be willing so that to get people to hear it, so as to confirm that that is not the only requirement, the only thing that made us to decide to appoint AAR. And as I have said again, management, the reason why they come to the board for they recommend, we just do not rubber stamp. We put our heads together and discuss, and we have fruitful and rigorous discussions before we come to any conclusion. Chair, I said on Monday when I came here, I do not regret a single decision that I made during my tenure at SAA and SAA Technical. And again, this tender resulted, in fact, in the saving of 800 million between Air France and AAR. There was a lot of saving here, and that's why I am saying I do not regret this decision. Air France was number 3. Air France was not number 1 at all. And Air France...
hang on, Ms. Kwinana. 2 or 3 things. One, I want to give Ms. Mbanjwa a chance to say something. She raised her hand. But I just want to say this because you have said something that Ms. Mieni said yesterday as well. Nobody says that when a recommendation is made by management to a board, the board is bound by or must rubber stamp what management says. Nobody says that. But it is expected that management would apply their minds, and obviously if they don't agree with the recommendation, if they don't go along, it is expected that they would be able to give reasons why they don't go along. So nobody says they are expected to rubber stamp. But also, I think Ms. Hofmeyer wanted to engage you on the reason that you gave. At a certain stage, if you have other reasons that you want to say, those were also other reasons, she will engage you on those. But it's important to get clarity on this particular reason that you gave earlier on and what is recorded. So it's not as if you won't be allowed to articulate other reasons if there were other reasons, but she will engage you on that. All right, Ms. Mpanjwa, Or has your issue fallen away?
Thank you, Chair. I'm just going to to draw the attention of the Chair and Ms. Hofmeyr to the fact that this term, supplier development, when it was explained by Ms. Memela, she did not explain it as BEE. She explained it as NIP obligations. I just want that to be also taken into account, Chair. Thank you.
Yes, I think, okay, Ms. Hofmeyr, let me
Yes.
rather, yeah,
No,
say nothing.
Indeed.
Yeah.
Look, I'm well aware of Ms. Mamela's testimony. That is why I've been saying this morning. There is a different way in which it was working in this contract, and that is effectively what Ms. Mbanjwa, as I understand it, is highlighting, because that's clear from Ms. Mamela's evidence. But I'm working with the evidence of the witness today. And Ms. Kwinana, the chairperson of the board of SAAT at the time, was one of the people who took this decision recorded on page 2305. The reason that we are focusing on, that was given by the board, was that Air France management and the BAC's chosen successor for this bid was to be rejected because they had resistance to align themselves with SART's developmental agenda, i.e. supplier development. And Ms. Kwinana has given her understanding of that, and I have shown her, and I conclude by putting this to you, Ms. Kwinana, that if your reason for rejecting Air France was that they were not BEE compliant, that is a wholly irrational reason, because we've just seen from the scoring that no party then was BEE compliant. So that reason can't be a basis for favoring one over another. Do you accept that?
And then let's go to the supplier development.
No, can I have your answer to that question? It is wholly irrational to choose one bidder over another on an aspect that they are all in exactly the same position on. What is your response to that?
Chair, you have just brought it to my attention that much as I am saying Air France was not BEE compliant, all of these were not BEE compliant. And in fact, you have also brought it to my attention that in the minutes, we were not talking about BEE. We were talking about supplier development.
I will argue in due course that Ms. Kwinana has been given 2 opportunities to answer the question whether it is irrational on the reason she gave this morning to have made the decision that she did, and she has failed on 2 occasions to give a clear answer to that. I'm happy to move on.
I just want to say, it's important, Ms. Kwinana, that you be judged in your own right, on your own evidence, what a witness you are, okay? But there may be a perception that before Ms. Mbanjwa made the remarks that she made earlier on, you had taken a certain approach with regard to what this reason recorded here meant. But after she had spoken, now you seem to say, oh, you seem to want to shift from that. Now, I'm just saying that it's very important that as far as possible, you are seen to be giving your own answers as you understand the position in terms of evidence. That's important. Ms. Mbanjwa?
Thank you, Chair. Chair, I just want your assistance and direction in this regard, so that in future I don't raise a hand if it's a similar situation. So I will put it hypothetically. What happens in a situation where there is a board resolution that says that the reason for the board to act was X, and the witness gives an incorrect reason, on which must she give an answer? Must she give an answer on the incorrect reason she is giving here at the commission, or must she give an answer on the reason that was given at the board meeting or by the board resolution?
Well, every witness is expected to speak the truth and give her understanding of the position. She just needs to give her understanding depending what the question is. She needs to give her understanding. But when you re-examine, you are free to see if there is clarification that's necessary in regard to an answer that she gave. But as long as she gives what to her mind is the truth, as she understands the position, that's fine. If it happens to be different from what is written somewhere, that's fine. She must just stay within her oath to speak the truth. Ms. Hofmeyr.
Ms. Kwinana, supplier development was going to be dealt with in a very particular way in this tender. What was your understanding of it at the time?
The little I understand, I now do not even know if I should state the little I understand, because if I do not read as you have there, then you will take me otherwise. So I'm just so uncomfortable to, maybe I need to Google as to what does that mean. So basically, I don't want to say in my own words, this is what it is.
Well, as I've just explained to Ms. Mbandra, Ms. Kwinana, a witness is simply expected to give evidence as she or he understands the position, or as he or she understood it at a particular time, and to the best of her recollection. You just say, at that time, this was my understanding. If it so happens that it differs from somebody else's understanding, as long as you are genuine to say, this is how I understood the position, you are fine. If you understood it in a certain way, and you are asked what was your understanding at that time, and you Google and say, I understood it like that, after Googling, when actually that's not how you understood it, then that's not truthful. So you just need to say the truth to the best of your ability, to the best of your recollection. Nothing more than that is being asked of you or any witness.
Thank you, Chair.
Yeah, okay.
My understanding of the supplier development is that a supplier must be able to develop another upcoming supplier. That's my understanding.
And as the board's reasons are recorded there, you rejected Air France because, on your understanding, it was not able to support an upcoming supplier. Is that correct?
Yes, Chair.
You see, the way that supplier development was going to work in the tender, and we confirmed this in Ms. Mamela's evidence, Chair, for the record, it's the transcript of the 12th of February 2020, page 53, lines 6 to 11. The way that the tender was structured is each of the tenderers had to indicate a commitment to supplier development, and they would be assessed on the basis of whether they made that commitment or not. The tenders would then be evaluated, And thereafter, they could give their proposals of how precisely they would commit to and what their plans were for supplier development. That was Ms. Mamela's evidence. The reason she gave it was because, well, amongst other things, she was shown that AAR and JM Aviation only submitted their supplier development plan after they were awarded the tender. And I, in fairness, found that a bit striking, because if it's a requirement of the tender, it should have been there before. But she corrected me and she said, no, all that was needed was an indication in the bid that you were committed to it, and then thereafter you could fill it out with the details. Now, that was the head of procurement's understanding. I understand you to say you rejected Air France on the basis that they didn't, in this bid, exhibit the requisite requirement to supplier development. But what I want to then put to you is Air France was in exactly the same position as JM and AAR. Both had indicated a commitment. Nothing more was required of them at the time of evaluation. So I want to understand from you, Ms. Kwinana, how that could then have been the reason to reject Air France.
As I said, Chair, there were many things that we talked about that resulted in us rejecting Air France. It would be good if we could listen to the discussions that we have in that meeting.
Yes, but Ms. Hofmeyer wants us to make progress, to say there is this one reason that has been given. Can we get to a point where we know whether you agree that that reason could not be a valid reason to reject it, to reject Air France? Then, once we are done with that reason, we can move to one or more of the other reasons that you say were also reasons why it was rejected. She just wants us to make progress, to say, okay, are we on the same page with regard to this reason, that this was not a sound reason to reject? Let's move to the next one. So she wants you to indicate whether you accept that since they were all, their compliance with regard to this was the same, it was irrational to rely on that to reject them.
I am not going to agree, Chair.
Yes.
I am not sure, as I am sitting here, if Air France had committed to supplier development. If the minutes are saying Air France failed to commit, or let me read it correctly so that I don't get misinterpreted. What page is that, Chair?
Maybe before we do that, but assume that Ms. Hofmeyer will take you to where we will see that. If indeed Air France, in regard to supplier development, was on the same level as the other ones, would you accept that it would not be rational, it would be irrational to reject Air France on the basis of something that you could find with everybody, or you could not find with everybody? In other words, it's like if Ms. Mbanjwa and my registrar here, they put in a tender for something. You reject my registrar's bid, and you say it's because he's black. The question is, but Ms. Mbanjwa is black too. Can't be rational. It's that kind of argument. So if indeed Air France had made a commitment which had been made by everyone else with regard to supplier development, would you accept that to rely on that reason To reject
Yes,
a France would be irrational.
Yes, Chair.
You accept, okay. Ms.
Chair,
Hoffman?
may I have a comfort break, please?
Oh, okay, all right.
Thank you.
Let's have a break of 10 minutes. We adjourn.
Yo.
in the board's resolution, which is the one that I think you've also referenced yourself in your explanations. You'll find that resolution at page 2305 of the bundle in front of you, DD 22F. So you need to go to 2305.
Yes, Chair.
Did you say 2035?
2305. Apologies, Chair. I might have
Well,
mixed them.
No, I think this
I
time.
do that often.
I think this time it was me.
Okay. Well, the record will show, Chair, in due course.
Maybe I was right on both
Maybe,
occasions.
maybe.
2305.
Indeed.
Yeah. Yes.
Ms. Kwinana, so the first reason is really recorded at the beginning of 4.1a, right? That's the one we've been focusing on. Management's rationale for the recommendations that Air France be awarded the tender was not substantive, considering the bidder's resistance to align itself with SART's developmental agenda, i.e. supplier development. I'm going to call that the first reason. It's the one we've been dealing with. And then it goes on and says, furthermore, the benefits as outlined by the submission as a result of selecting Air France were not compelling enough to position the latter as the preferred bidder. Now, I understand your evidence today to be what's really living in that second reason is this price concern that you had, that Air France was actually more costly than the AAR JM Aviation bid, and that selecting AAR and JM Aviation over Air France gave a saving to SAAT. Have I understood your evidence correctly there?
Maybe, Chair, we need to go to these benefits outlined in the submission.
Yes, we could do
but
that.
she wanted you to confirm whether her understanding of your evidence is correct before we go there. Do you want her to repeat?
Yes, please, Chair.
Okay.
See, I understood you earlier to say the other big factor for you in making this decision to go for JM Aviation and AAR and not Air France was because JM and AAR was going to be cheaper than Air France, and I think you gave a savings of about 800 million. Was that a key reason why you decided not to go with Air France and rather to go with JM and AAR?
Yes, Chair. And I said the other day, Air France is an airline, and it gets its components from AAR, because AAR basically is the components manufacturer. And therefore, as we have been using Air France for the past many years at SAA, we have in fact been using the middleman. So that's why basically Air France was more expensive than AAR. So we have considered a lot of things. And in fact, we also did consider the risks of taking on board the AAR, considering that it's a new supplier. So that's why, Chair, I'm saying it would be good if you could listen to our interactions as the board members, including management.
Ms. Kwinana, you gave that evidence, I remember it, about AAR being the sort of world supplier the other day of these parts. And I recall you saying that that was some of the information you learned when you did your due diligence trip in the US. Is that correct?
Yes, Chair.
Yes, because that fact was not disclosed in the bids of Air France, so you're aware of that?
So?
No, are you aware of that?
I think she didn't hear the question.
Oh, sorry, I thought you were asking a follow-up question, why does it matter? I thought you said so. No, I'm saying, are you aware that that fact that Air France secures its parts from AAR was not disclosed in any of the bids?
Yes, that's fine.
So you were making your decision then on the basis of something that you'd learned on the due diligence trip to the US, correct?
We made the decisions based on what was recorded here in the minutes. So the fact that AAR is an original manufacturer is not here, and it was not one of the reasons. But I'm saying the reason why France was higher is because of that. But that's not the reason that was put here. Yes, and therefore, the reasons that I am telling you about confirm that the decisions that we made were the best decisions, Chair.
Ms. Kwinana, I will argue in due course that in forming your decision not to award Air France, despite management's recommendation that they should be awarded this tender and rather to go with JM and AAR was based on information that you obtained when you went on a trip to the US and received various benefits from AAR. Do you have a response to that?
Let me repeat, Chair. When management brings a recommendation to the board, we apply our minds. We made the best decision of the company. I am repeating again, Chair, we do not rubber stamp. That's why I am saying it would be good if you had the recordings so that you can show how best we made the decisions at the time. So, Chair, management did make a recommendation, and therefore we did not have to agree with the recommendations. Based on the discussions by the board, we agreed that the award should go to another company.
Chair, just to note that there was no denial in Ms. Kwinana's answer to my question that that was information that she obtained when she was on that trip. Instead,
Chair,
justification was given for why the decision was made.
Chair, I deny that. I'm saying the reasons that were put here in the document are the reasons, but I am saying, as I am sitting here with the information that I know, it was still the best decision.
Let's go, if we may, to what you were going to do to alleviate the concerns that management had raised about giving the tender to JM and AAR, because that's the third thing that's recorded on this page 2305. And you'll see that under that paragraph 4.1a, there it records the concerns regarding JM-AAR, especially management's view that this bidder was lowballing, could be mitigated by reducing each party's obligations as well as terms and conditions to writing. What does that mean, Ms. Kwinana?
In simple terms, Chair, it means that if, for instance, AAR said they're going to supply spares to the extent of 1 million or 1 billion, then they cannot come back and say, we did not cost for these spares, we did not cost for these spares. They need to give us exactly what they said they were going to give us. Because, you know, with tenders, you would lowball, and then when you are inside the client, then the costs escalate, and then you find out that after all, it was not the cheapest. So basically, when we were saying here, that needed to be reduced in writing. We were saying, as AAR said, they are going to give us these at this price. We're not gonna take any increase. So basically, that was what was said when we were saying reduce it in writing.
Lowballing is a concern. If you'll see in the management's recommendation that we were looking at previously, and if you want to find it, it's at page 2281. you'll see there that management records under the heading JMAAR, under the second bullet, that this is a section where they're identifying risks identified within the tender. And in respect of JM and AAR, under the second bullet, management's concern was sudden drastic cuts to the tender prices with a reduction of more than $40 million raised the fear of lowballing to get the contract and doubts on sustainability. Do you see that?
Yes, Chair.
Yes. So that was the concern, and as I understand it, you weren't too worried about that concern because you would tie them into a contract that would ensure that they didn't wiggle out of their commitments. Is that a fair summary?
Yes, Chair.
Yes. If we just look at yes, that lowballing that happened, if you go over the page to 2282, you'll see at the top of the page the cost impact is recorded there. And you'll see there, if you go across it, Supplier is in the far left-hand column. You've got Lufthansa, JMAAR, and Air France. Air France is sort of shaded because that was management's selected preferred bidder. And then if you go across, the columns are fleet, value per annum in US dollars, value per annum in ZAR, value for 5 years in US dollars, value for 5 years in ZAR. I'd like us just to look at the value for 5 years in US dollars. Do you see that the JMAAR price is about 82 million US dollars and Air France is 88 million US dollars? Do you see that?
Yes, Chair.
And so that difference is really just a difference of about 6 million US dollars, correct?
Yes, Chair.
Yes. And the concern was that to get JM to this 82 million, remember there'd been back and forth. They kept going back to the bidders to say, revise your pricing, revise your pricing. What had happened was to get it to this 82, it had dropped its prior price by 40 million. That's a considerable drop, isn't it?
Yes, Chair.
So did you share management's concern that lowballing was a real issue if they dropped as much as 40 million in the last round?
Yes, Chair.
Yes, and they were very close actually when they ended up. I mean, in order of magnitude, they were just 6 million less than Air France, correct?
Yes, Chair.
And there was no concern expressed, as I recall it, that Air France was lowballing, was there?
Yes, Chair.
So, given
Yes, there was. Yes, there was not.
there was no concern that Air France was lowballing, was there?
There was no consent, Chair.
There was no concern. Thank you. I understand the ambiguity
Yeah,
potentially.
they say it's a South African thing.
Yes, yes.
we say yanye.
Yes, exactly. Okay, so they dropped by 40 million, but despite that, the board resolved that if it went into the contract and they were tied to the contract terms, then everything would be okay, correct?
Yes, Chair.
And did you take any steps to ensure that that was then implemented in the contract that was concluded?
As we said, Chair, in the minutes, we said, let me read it again. What was said there was said in the board meeting that we need to tie them. Yes. And now, when you say, did I see the contract? I did not see the contract, Chair. The reason being that the contracts after the award, in fact, that is also what I was trying to explain with Swissport. After the award is done, the legal team goes and draws the contract. So now, whether the minutes of the board do agree with what is in the contract, then that is basically outside us. It is now the duty of other assurance bodies within the organization. Therefore, Chair, I did not see the contract.
Ms. Kwinana, you'll remember that Mr. Perry's evidence that we looked at the other day on affidavit says that you did see the contract, that you actually at a meeting demanded that it be signed and that arrangements be made to go and retrieve it. And he said that you had said at a point in that meeting that people were not to leave the room until the agreement was signed. I understand your evidence previously to be that you deny that you were ever at that meeting, correct?
Chair, I was saying, after the award of this contract, there was a lot of unhappiness from the people who were not part of this process at all. We had, I received a letter of complaint from the chairperson of the board. I received a letter from National Treasurer as the chairperson. And then there was also the media. And rightly so, because this is a big contract.
I'm going to interrupt you, Ms. Kwinana. Remember, the question was whether you confirm that your position is that you were not at that meeting that Mr. Perry talked about. That was the question.
I'm trying to answer it, Chair. I'm saying...
Try and go straight to it as much as possible, because your answer may be, no, I didn't say I was not at that meeting, or yes, my position is that I was not at that meeting.
Okay.
I just want us to make progress.
I was at a meeting where I sat with management to say there is this concern. Please put together all the files, put together the contract, take everything to National Treasurer. Yes, I was in that meeting where basically we were addressing this unhappiness.
Okay. Ms. Hofmeyer.
Thank you, but you deny having at that meeting demanded that no one leave the room until the agreement was signed. Is that correct?
Definitely.
And you didn't ask for it to go and be retrieved. Is that correct?
No, Chair.
And Mr. Perry also said that before he signed...
I'm sorry. She asks, is it correct? You say no. Is it no, it is not correct? No, it is correct. I just want to... I want to make sure we all understand your answer in the same way.
Chair, I was at a meeting which was addressing the specific issues. Yes. So
of unhappiness. I think, Ms. Hofmeyer, you might have to repeat your question so
yes.
that, and then when you answer, I just want to make sure when you say yes or no, that my understanding is what you intend to convey.
I think it'll be helpful if I change the framing of the question.
Yes, okay.
Ms. Kwinana, at that meeting, did you demand that no one leave the room before the agreement was signed?
I did not demand, because my understanding was that the agreement was signed.
Did you at any point prior to that meeting push for it to be urgently concluded, the drafting process?
No, Chair.
Who is Ms. Cookie Constance Mbeki?
She is the head of legal.
Where?
Then she was the head of legal at SAAT.
Right. Do you remember having an interaction with her during the drafting process for this contract?
No.
because she has previously given an affidavit to the Commission. It was dealt with in Ms. Mamela's evidence. I can take you there so you can read it yourself, or I could just read you it. Would you like to see it in front of you?
Yes, Chair.
Certainly. We will need, Chair and Ms. Mbanjwa, DD 25B. And you'll open it, the first page of the affidavit is page 464. Yes, and page 464 is where it commences. B, 464. No, I've just, it should be in 25B, page 464. 464. Yes. Oh, some pages fell out. Thank you. Ms. Kwinana, do you recall having any interactions with Ms. Mbeki about the drafting? Because I understood your evidence previously to be, once the board makes the decision, you leave it to management to execute it. Is that right?
Yes, Chair.
So, am I understanding correctly? Then you wouldn't have been following up with the drafting team or anything like that. Is that right?
Yes, Chair.
And is your evidence that after the board gave that, made that resolution on the 9th of May, you didn't thereafter become involved or follow up about the drafting at all?
No, Chair.
No. And you've already told us you dispute Mr. Piri's version about that meeting, so I'm leaving that. Now, what Ms. Mbeki, who was one of the people involved in drafting the contract, has said in her affidavit here, and we can pick it up at page 473. Paragraph 25. And if you go to page 25, paragraph 25, she's been dealing with various processes in the drafting, and about 2/3 of the way down on paragraph 25, she says that she'd had a conversation with Ms. Mamela, Advocate Mamela, and she says there's a sentence sort of 2/3 of the way down, during the telephone discussion. Can you see that, Ms. Kwinana?
Yes.
It says, during the telephone discussion, Advocate Mamela told me that she received a complaint that I keep on raising issues which were already discussed before I joined the team the previous day. And as a result of my conduct, the discussions were taking longer than necessary. She also told me that this concern was also raised with the then Chief Executive Officer of SART, who was also the acting Group Chief Executive Officer, Mr. Musa Zwane. I admitted that indeed I'd been alerted by the team that a lot of the issues I was raising were already raised, discussed, and resolved the previous day. And then she goes on at 26 to say, on the same day that Advocate Mamela told me about the concern from the contract negotiation team, I had a telephone discussion with Mr. Zwane, who informed me that he was in a meeting with the then chairperson of SART board, Ms. Yakhe Kwinana, and that I am on speakerphone. He told me that I'm informed that the contract negotiation process, that I'm slowing down the contract negotiation process by raising issues which had already been dealt with, and that he was requested to intervene. Do you recall this conversation that you were placed on speakerphone?
No, Chair.
Do you deny that it took place?
I don't remember it, Chair.
So it's possible it could have.
Not with contract negotiation.
You would not have
at
been
all.
involved.
Yes.
So your answer is you weren't involved in this
I
conversation.
wasn't involved.
Because if it was just you and Mr. Zwane, and he said that he had been requested to intervene, do you agree it's a fair assumption that that request would likely have come to you, from you?
No, definitely it did not come from me.
And she goes on and she says, he told me that the purpose of his call was to ascertain what was going on and that he wanted to hear my side of the story. He gave an opportunity for me to explain my frustrations, and then she goes on and talks in some detail about the issues, etc. What I'm interested in is this reads, Ms. Kwinana, as yet another member of the SART team, now on the legal side, saying that you were involved in following up about the drafting of this contract. Is she giving false evidence by placing this version before the Commission?
She is, Chair.
And Mr. Piri is also, correct?
Mr. Piri is also. And in fact, Chair, maybe I should have been given Rule 3.3 here so that I can answer adequately.
You were alerted to the fact that it would be part of what was referred to today because it comprises part of Ms. Mamela's bundle. But you've given your answer. Is there anything you feel that you haven't been able to say?
No, Chair, but I am angry that knowing the processes, how would I go and say how far is the contract? The board is not involved there. In fact, that is what I have been explaining. The board is not involved in the documentation of the contract.
Ms. Kwinana, let me, in fairness to you, say I absolutely accept that. When processes are running correctly, the board should never be involved in that. It may on occasion, and I think this is a point that the chair raised previously, if it's really important that something be in a contract when the board approves it, it may be appropriate from a corporate governance and a procurement perspective that the board checks again that it's there. But actually being involved in driving the process, in rushing it along, is something that board members should never do. Are we agreed on that?
Agreed.
Yes. What we're probing today is why many people at SART, many might be exaggerating, at least 2 people at SART, say you were playing a role in this contract, which is contrary to the proper role of a board member, and we're exploring it today because the theme that is emerging from all these bits of evidence is that you played a role that is not an appropriate role for a board member to play, and if you received any benefits out of this contract, it would indicate that you were pushing for these bidders to be favoured and the contract to be signed so that they could be secured their revenue stream. And that's why I must, in fairness, put these to you. Just wanted you to be clear about why I'm going there. Chair, I then propose to move from this aspect.
1 second.
Oh, sorry.
Ms. Mbandra.
Chair, thank you. Chair, I decided to raise this concern after the witness has answered because I take cognizance of your warning to me the other day to say I must not be seen to be assisting the witness. What I now have, Chair, is a concern with the manner of questioning by Ms. Hofmeyer, specifically on this question. I won't be long so that I can take it to re-examination. I just want to state my concern so that in future, what Ms. Hofmeyer does, she reads a statement that does not say that the witness was there. And the statement clearly does not say that she was there. It is hearsay. Somebody is saying, I'm with Mr. X. And secondly, when that person speaks, that person does not speak in the plural, speaks in the singular. which means that I don't mind Ms. Hofmeyer putting the questions to the witness, but I object to Ms. Hofmeyer making the statement to be what the statement is not, because this is what is causing difficulty with this witness to answer. So if she can in future just be careful of that. If the statement does not say, I as Yakhe Kwinana am saying this, somebody says there was a hearsay to that, and then she is bombarded and conclusions are made, that becomes unfair cross-examination.
Well, just, do you want to draw my attention to the specific part that you are talking about?
Thank you, Chair. If I can use, for instance, this paragraph that we are at now. It is DD 25, page 473.
47?
Yes, it is this.
474.
47. No, it starts at 473.
Yeah.
And then, reading from paragraph 26, it says, I had a telephone discussion with Mr. Zwane, who informed me that he was in a meeting with the then chairperson of SAT. It goes over to page 474. Who informed me that he was in a meeting with the chairperson of SAT. This person did not see Ms. Kwinana there. She says somebody phones me and say, I am in a meeting with the chairperson of SAT. That is Yakhe Kwinana. He informed me that he was informed. And then it continues, it says, he told me that the purpose of his call, without arguing, Chair, I know this is not the time. We can see that Mr. Zwane here is speaking in the singular. He doesn't say that, this lady doesn't say, he told me that the reason for their call. So even on Mr. Zwane's ipse dixit to this question, the witness was not part of that conversation. That is clear from this affidavit. And now here is where my concern is. My concern is what now Ms. Hofmeyer does is to say that this statement, which clearly does not say the witness said anything, is confirmation of the fact that the witness, I don't mind if she makes it like that, but what worries me is when she pushes it and presses it and makes it a fact. If we can just get us.
Ms. Hofmeyer?
Chair, I was quite careful to be very faithful to Ms. Mbeki's words, and it was in response to her very words that I asked Ms. Kwinana for her version. And all that I did thereafter was to explain to Ms. Kwinana that, in essence, answers about the way boards usually operate is not where we're going here. I wanted to establish with Ms. Kwinana that we are on common ground with that. What's being explored is the extent to which there is evidence from others that suggest a greater involvement. And in fairness to Ms. Kwinana, I must put what Ms. Mbeki said in her own words. If Ms. Kwinana would like to give the answer that Ms. Mbanjwa has just given, which is, well, look, you can't even rely on this because it's Mr. Zwane saying that I was in a room that I was not in, that is, she's fully entitled to give that answer. What is difficult is, again, with respect to my learned friend, a situation where the type of answer that it might have been useful for Ms. Kwinana to give is then brought in through what is essentially argument or re-examination.
Yes,
so my request, Chair, would be that we do reserve it for that purpose. We are going to have a re-examination session today. My suggestion is these proceedings are going to move much more efficiently if we do that.
Okay, let's move on.
Right, so Ms. Kwinana, I'd like to leave the decision that the board took and your involvement thereafter in awarding the contract to JM and AAR, and I want to go back to actually where we left off on Tuesday, which is these monies that you received from JM Aviation, its bank account into Zanospark's bank account, Ms. Hendricks, who directly deposited money, and the evidence that you've given the Commission on that score. Now, Ms. Kwinana, I must say, after Tuesday's evidence, it became clear to me, certainly, and please tell me if you disagree, that you really are, I think probably from about the time you left SART, you've been running quite a serious Forex trading business. Is that a fair summary of what you've been doing?
Yes, Chair.
And you did indicate in your evidence that you have ensured in conducting that business that you are FICA compliant. That's compliant with the Financial Intelligence Center Act, correct?
Sorry, can you repeat the question?
Yes. I understood your evidence the other day to be that you have ensured that you are, as a business, FICA compliant. Is that correct?
I said the business is FICA compliant, but I do not need to have a license to do Forex trading.
Yes, no, I understand that difference. You dispute the evidence from the FSCA. We looked at their affidavit. You said, notwithstanding what they say about the licenses needed, I don't need that license. You and I agree on that. What I understand you to say, though, is you do accept that you are an accountable institution under FICA, and so you must be FICA compliant, correct?
No, Chair. I'm not an accountable institution under FICA. The accountable institution, let me get it for you in my red file, which institutions are accountable in terms of FICA.
Sorry, could I just ask, why would you need to be FICA compliant if you weren't an accountable institution under FICA?
No, FICA that I'm talking about is the normal FICA that everybody must comply with. Like, for instance, the copy of the ID and the proof of address. But let me read to you the companies that must comply with FICA as the financial institutions. It's the insurance companies. Zanospark is not an insurance company. Hedge fund managers, retirement fund managers, credit ratings companies, capital market companies, Forex brokers. We are not the Forex brokers. We are Forex traders. And therefore, we do not have to comply with FSCA requirements.
This is the Financial Intelligence Center Act, right?
Yes.
So you're not a Forex broker, you're a Forex trader.
Yes, and in fact, even the Forex brokers, it's not a mandatory requirement that they must comply, because there are Forex brokers that do not comply, and it's not a requirement, but it is advisable that they can comply.
I'm going to come back to FICA in a moment. Just tell me, but you said you do have an obligation to get IDs and other things. Where does that obligation come from?
From our own requirements, because we need to put everything in place.
But then why do you call it FICA documents or FICA compliance?
Maybe it's the loose term. Like, for instance, when you go to the bank, they say they want to FICA you, they want proof of address, they want the ID. So
yes, because they need to be, they are accountable institutions under FICA, right? So yes. I understand your evidence to be, you're not an accountable institution under FICA, but you just engage in good practice. Exactly. Is that right?
Yes.
Right, okay. Under FICA, sorry, let me move on from that. I'll come back to the FICA aspect in a moment. On Tuesday, you did say, though, and I think it's part of your good business practice, that you know your client documents from your clients. Yes. Like if you were obliged to do so under FICA, you would have been obliged to get, correct?
Yes.
Yes. And those documents you have not provided to the Commission, correct?
No.
No. And were those, is that because they were on that server that was confiscated?
Yes, Chair.
Yes, okay. Now, that server, as I understood your evidence earlier, was confiscated for non-payment in February 2020. Is that correct?
Yes, Chair.
Yes. And similarly, the annual investment statements that you say that you prepare, you don't ever email because of confidentiality concerns. You print them out and then you go and hand deliver them. Is that correct?
Yes, Chair.
And you also indicated that you deliver them in January of every year, correct?
Yes, Chair.
And those documents you also couldn't provide to the Commission because, despite the summons that you received, because of the confiscated server. Have I got the evidence the other day correct?
Yes, Chair.
You did say, however, in your evidence that you weren't certain that the confiscation happened in February 2020. Is that right?
Yes, Chair. I even said the date may be wrong.
Yes.
But the confiscation is correct.
It did take place, indeed. So, if we had been in contact with Onero, who you said was your service provider, and they indicated that the confiscation actually occurred in April of 2019, would you dispute that?
No, Chair.
Okay. So, right, let's move on from that for a moment. On Tuesday, in your evidence, we looked at the JM agreement that Ms. Sokulu sent to Ms. Mamela. Do you remember that, when the bid was still open and she was asking for Ms. Mamela's input on it? Do you recall that?
Yes, Chair.
And in terms of that JV agreement, you would have seen in the email, JM Aviation was going to earn 5% on all the invoices generated by AAR. Were you aware of that at the time, that these decisions were being taken?
No, Chair.
I just want to get a sense of how much value this contract was for JM Aviation. And I know that you're an accountant, which I am not, so you might be able to assist me. The value of the components contract, we've received evidence previously in the Commission, is about, over the 5 years, 1.5 billion. Does that accord with your understanding?
Yes, Chair.
Now, 5% of 1.5 billion on my calculation is 75 million. Does that sound right to you?
Yeah, maybe.
Yeah, we could do the I mean, I did do it, but sometimes when I've had accountants here, they can do it in their heads, so I'm always just a little bit cautious. So 5% of the total value of that contract, if I've done my calculation correctly, is about 75 million rands worth of business for JM Aviation. Do you accept that calculation?
Let me get my calculator, Chair.
You can't trust these lawyers, Ms. Kwinana.
No, you certainly shouldn't. Not on matters of numbers.
And I can't blame you.
So,
how much
I'm not
is it, Chair?
interrupting.
Yes.
I would just like to be given the page, if Ms. Hofmeyr can kindly give me the page where there is 5% of...
I'm going to have to just remember where it is. It's in that email, so it'll be in the Mamela bundle. It's the... I'll be able to find a quicker reference. Sorry, let me do that.
So I'm calculating
5%.
1.253. 1.253.
5% of 1.5 billion, I think. Is that correct, Ms. Hofmeyr?
Yes.
5% of 1.5 billion.
This is 1.253. 636,151.
Sorry, 5% of 1.5 billion is what?
Where is 1.5, Chair?
No,
Okay,
the value of the contract. over the
Yeah.
5 years is 1.5 billion. So I just want a calculation of what 5% of 1.5 billion is.
The value of the contract, Chair, according to DD 22, page 2282, is 1.253.
Well, 5% of 100 million is 5 million.
No, sorry, I understand where Ms. Kwinana and I are at odds. You're absolutely right. On that page, when the submission was made to the board, it was valued at about 1.25 billion, right? The evidence of Mr. Human, who appeared before the commission, who at the time was employed at SART, was that there had been overruns on the contract and that it was in the end going to be 1.5 billion. So that's why I give you
I
that
see.
figure. Oh, we're on the same page. So can you just do me a calculation of 5% of 1.5 billion?
I think you were right about 75 million.
I think so too,
Yeah,
but I
think
want to
you are
give the
right.
witness an opportunity.
I'm not an accountant, but
No.
I think you're right because 5% of 1 billion would be 50 million, I think.
That's 75 million.
Yes. Okay, so we're agreed on that.
So lawyers aren't so bad with figures, Ms. Hoffman.
Yes,
Accountants
sorry,
are
Ms. Mbanjwa had the request. I can give it to you, Ms. Mbanjwa. The reference is DD 18, page 339.
Maybe we can also be assisted with one other thing, Chair, because for us it will help with re-examination as well. According to also what Mrs. Kwinana raised is also what I saw, because I thought that the value of the contract was supposed to be in the submission, in that board submission. Now, is it Ms. Hofmeyer's conclusion that actually that value that was in the board submission was an incorrect value?
No. Ms. Mbanjwa, it's the evidence of Mr. Human. He said, he's not saying that's wrong. He said, as the contract has developed over time, it has become more costly. So in the end, because it was running currently, I understand it's now been cancelled, but it was running currently, and so what it was going to end up costing SART was about 1.5 billion. That's why I'm using that, because if that's what it did end up costing SART, then JM Aviation had a look through to 5%, and that's about 75 million.
You know, so I really don't want to hold up. I hear this evidence of Mr. Human, but can we be referred to something that proves that at the end, this was the value?
Chair, this is really
Yes,
not...
Yes, she's saying Mr. Human's evidence. Mr. Human came and gave evidence, and that's what he said. Obviously, if you want to calculate 5% of the amount that is reflected there, you are free to do so.
Thank you. No, I think I've held you up enough, so thank you. We may continue.
Okay, all right.
Thank you.
Let's move on. Thank you, Ms. Kwinana, for confirming that the lawyer was right about figures.
Okay, so out of the AAR JM Aviation contract, JM Aviation stood to receive revenue of about 75 million. If Mr. Human is right, that its ultimate value is 1.5. If it's a bit less, 1.2, we can do the calculation. And it'll be some tens of millions less than 75 million. Do you accept that as well, Ms. Kwinana?
Yes, Chair.
Yes. And then they also benefited from the sale of the GPUs to them, and then their ability to on-sell it to Swissport. Is that correct?
Sorry, what's your question?
That JM Aviation also benefited from the fact that SART sold its GPUs, which it was then able to sell on to Swissport, correct?
I can't confirm this one.
Do you not have knowledge of that?
I don't know if they unsold and benefited.
Oh, okay. Let me help you again. The evidence is that SART sold it to JM Aviation at about 3 million, it was 3.3 or something, and the next day, Swissport paid for those same 12 GPUs at about 9.8. So I've always worked with the difference being about 6 million rand. Do you accept that if JM Aviation bought them for about 3 million, and the next day they could sell them for 9 million, they benefited by the difference, which I'm going to say is about 6 million. Do you accept that?
There was also a board submission in respect of this.
Yes, my question is, do you accept that if they bought them for 3 million and sold them for 9 million the next day, they made 6 million out of that transaction?
There was a board resolution in respect of this, Chair. And in this board resolution, there were some also questions that were raised.
Yes,
In
but
res-
hang on, Ms. Kwinana. She's just asking you whether you accept that reasoning. She's saying, if you buy something for 3 million today and you sell it for 9 million rand tomorrow, do you accept that it means you have made a 6 million rand profit?
Not necessarily, Chair.
Okay, all right. Ms. Hofmeyer?
Why not?
It's because if I make an example of a car, you sell a car, you buy a car today, Chair, for 200,000. It gets registered today and you sell it tomorrow. You sell it tomorrow, you can sell it tomorrow at 150 because of the depreciation.
Indeed, indeed. But the facts are, they bought it on day one for 3 million and they didn't sell it at a depreciated value. They sold it the next day at 9 million. How could they possibly not have benefited in the order of 6 million? There's no depreciation issue. Buy on day one at 3 million, sell on day two at 9 million.
Still, Chair, it also depends on the whole lot of things. I'm talking about the depreciation. We all know that the car depreciates it the moment it gets out of the showroom. It has already depreciated.
Yes, but you see, you are responding to a general principle. You are saying, in effect, that's not always the case. There are circumstances where you might have to sell something for lower than the amount you bought it the previous day.
Yes,
You
Chair.
make the example of a car. But what she's talking about is where it is a fact that they sold it for more than the price they paid for it. So your example doesn't apply. They bought this for 3 million. Today, tomorrow, they were able to, the following day, they were able to sell it for 9 million. How can it not be that they made a profit of 6 million rand? How can you not agree with that?
Again, Chair, in the example of the car.
Yes, but leave out the example of a car. Talk about what she's talking about.
Talk about the GPUs.
Talk about any purchase.
Then
Day
let me
one,
talk
3
about-
million, tomorrow, sell for 9 million.
Then let me talk about the purchase of a car, Chair. Let me make an example of the purchase of a car.
But,
No, but the
your own evidence says, in the case of a car, you won't sell the car for a higher price than the one you bought it for. That's your own evidence.
Yes, Chair.
But she's saying to you, if you buy anything today and you are able to, for 3 million rand, and you are able to sell it for 9 million rand tomorrow, obviously you have made 6 million rand profit.
If you haven't made any improvements, Chair.
Yes, if you have not
haven't-
incurred any expenses,
If you haven't incurred any other expenses.
then you agree.
The answer is yes.
Okay.
Thank you.
All right, 1 second, Ms. Mbanjwa.
Thank you, Chair. I just want to remind Chair specifically. You will recall, Chair, that this was the same question that was placed in front of Ms. Memela. And then what we had said then, we had said that the determination of the
Chair,
price-
I'm so sorry, Ms. Mbanjwa.
Yeah.
I really do want to place on record now that we will argue in due course, and that is the only reason I'm interrupting Ms. Mbanjwa, because I have to interrupt to tell you that if at this point you have interjected in a way that is going to be viewed as coaching this witness, we are going to make that submission in due course. I need to tell you that that is what I'm going to do in fairness to you, but please proceed if you'd like to carry on.
But as I've been saying also, Ms. Mbanjwa, I'm very concerned about that.
Yes,
And
but
it's not
but
doing-
it's not that.
It's not doing justice to Ms. Kwinana, who I believe can mostly answer questions on her own.
Yes, but Chair, you are going to listen to what I'm going to say, and you will see that it has nothing to do with the answer of Ms. Kwinana.
Yeah.
And actually, Chair, maybe this may appear a joke. I'm not making light of this. She is actually Mrs. Kwinana. There is somebody who tweeted, "Oh, Mrs. Kwinana, no wonder they are not even married, they are gangsters." So maybe we should emphasize that she is Mrs. She has been married for more than 20 years. Thank you, Chair. But Chair, what I wanted to say is this, with your permission. When Ms. Memela was giving evidence the last time, we requested a specific affidavit, the affidavit of Jules S. And Jules S. was at Swissport. One of the things, and that affidavit, we confirmed with Ms. Hofmeyer that she is in possession of that affidavit. That affidavit expressly stated, and we drew the attention of Ms. Hofmeyer to that, it expressly stated that the GPUs that were sold, some of them were broken, and they were taken for repairs, which means costs were incurred. I was just reminding the Commission that the issue of whether it was 6 million the profit is fully set out in that affidavit. Thank you, Chair.
Ms. Hofmeyer, please
Thank
move
you.
on. The issue of Ms. Kwinana, Ms. or Mrs. Kwinana, I've understood that Miss is for both Mrs. and Miss, but I may be wrong. Ms. Hofmeyer, what's your understanding? Ms.
I
Hofmeyer.
had certainly understood that to be the case. Sorry, I was writing myself a note so that if Mrs. Kwinana wants me to refer, you see, I've written Mrs. because
Yeah.
it's my tendency to always use Ms. so that
Yes.
it neutrally covers both. But if it's important to Mrs. Kwinana that I refer to her as Mrs. Kwinana, then I will endeavor to do so.
Guide us.
It really doesn't matter to me, Chair.
It doesn't matter to you.
No, I was just putting in a light moment.
Okay, no, but it's important. One does need to be sensitive to some of these things. Okay, all right.
Thank you.
I wanted to think now whether to say Mrs. Hofmeyer or Ms. Hofmeyer.
No. I far prefer Ms. So I'm happy to go with that.
All right, yeah.
Excuse me, Chair. I'm even embarrassed to ask for another break. Maybe it's this water, Chair.
Oh, okay. Another break. Oh,
Chair.
okay. Okay, let's take another break. 10 minutes?
5 minutes.
5 minutes will do?
Yes.
Okay, 5 minutes.
Thank
We
you.
adjourn.
All rise.
head judge, I was so embarrassed. And if, Chair, by my interjections, I was taken to have disrespected you, I sincerely, from my heart, apologize. That was never the intention. You are one of people we as black people look up to. You are a trailblazer, and I'm sure you know of that. So seriously, my apologies.
No, that's fine, that's fine. Thank you. No, I just wanted to also talk, Ms. Mbanjwa, about re-examination, so that as Ms. Hofmeyer continues, you can have an idea of how much time I have in mind I would give you. You might, when the time comes, maybe ask for more and I'll hear what you have to say, but it might help that you have an idea of what I have in mind so that you can work on the basis that if that's the time I will give you, you try and identify really the important issues you want to re-examine on. Because if I tell you later, you might say, had I known before, I would have tried to limit, but I've worked on too many things because I thought I was going to have more time.
Thank you.
Now,
sorry, Chair.
the time that I would like to give you is not more than an hour. Let me tell you why I have that in mind. I've looked at how much time lawyers who have appeared for witnesses seem to generally take in re-examination since we started in August 2018. As far as I can recall, there are no more than 2 who have taken about 2 hours. Most of the time, a lot of lawyers who represent witnesses will say, I just want to ask 1 or 2 questions. They take a few minutes. Some don't even re-examine. I recall, for example, sometime early, I think last year, if I'm not mistaken, Mr. Vim Trengov was representing, I think, Mr. Jonas.
Yes, indeed.
Yeah, when it was his turn to re-examine, he said, Chairperson, I'm not going to re-examine the examination by the evidence leader has covered everything. There are many others. Mr. Mpofu was representing somebody some time back. He didn't take, I think he didn't take more than 15 minutes in re-examination. Mr. Ngabesha was here last week or the week before. He asked 2 or 3 questions in re-examination and said that he was covered. So generally, lawyers who represent witnesses, they have felt covered by the questioning and the evidence that comes out when a commission evidence leader has been asking questions. So I'm just saying, an hour should, if one looks at what other lawyers generally have taken, should be fine. So, but if when you start re-examining, you complain, you want more, let's talk then. But I just want to give you an idea so that as Ms. Hofmeyer continues for the next hour or so, you are able to say, okay, if I don't get given more than an hour, this is what I want to cover because this is what I consider to be important.
Thank you, Chair. To be fair, Chair, much as I thought with Ms. Memela I would need more because the situation was different, up till now, I think the hour will be sufficient. The only thing which I will ask, with your permission, Chair, is after Ms. Hofmeyer has finished, can we maybe time the re-examination to be just after lunch so that I can talk to the witness a few things? I don't know if that is possible. I know it's a Saturday, and there may be time constraints on your part. So if that is not possible, maybe I can just have, I don't know, the break that Chair can be prepared to give us before we embark immediately on re-exam.
Yes, look, let's see how it goes. I had hoped that we would be done by 1 o'clock, but I don't think we will be done. Let's see when Ms. Hofmeyer is done and then take it from there. Okay, all right, Ms. Hofmeyer.
Thank you, Chair. Ms. Kwinana, I want to just get your confirmation of certain facts. We have traversed them over the last 2 days, but they're an important background to where I'm going in the questions. So it's just helpful to remember also because we've had this break of 3 days. We've seen this morning, were involved in the SART board's decision to award the components contract to AAR and JM Aviation, correct?
Yes, Chair.
And you were also involved in the SAA board's decision to approve the contract with Swissport. That was that resolution we looked at the other day of March 2016, correct?
To approve, as I said, Chair, this 2012, that was 2012, and you refused, Chair, that I should go back to 2012. In 2016, the contract was awarded in 2012. So in 2016, what happened is there was a board submission to approve the terms and conditions of the 2012 award. So, Chair, again, when the submission comes, it doesn't come with a contract, but it comes with the terms and conditions. And then the same as I was saying at AAR, after that, the people go and do the contract. But that contract, the terms and conditions that were approved were relating to the award that was done in 2012.
Ms. Kwinana, I know that you have given evidence about the old 2012 award. I just want to get confirmation that you were part of the board that decided on the 14th of March, and I'm reading from the resolution now so that there can be no dispute between us, to approve the contract to be entered into with Swissport South Africa for the duration of 5 years, commencing on 1 April 2016 to 31 March 2021. Do you confirm that?
What page is that, Chair?
It's in Exhibit DD 19, page 132.43. Let's get that in front of you. Hmm. 19. Oh, apologies, it's 19A. And it's 132.43. .43.
Oh, yes, Chair.
Super. Thank you. Now, it was pursuant to this contract that the sale of the GPUs took place. You'll recall that I took you to the contract the other day and I showed you clauses 8.1 and 8.2. Do you accept that?
What were these clauses saying? Can you remind me?
Yes, the clause 8.2 says that it's a requirement of the contract that we've just looked at that was approved, that Swissport purchase SART's GPUs.
Oh, yes.
Yes, right. So what that means, Ms. Kwinana, is that If you'll just give me a
I'm
moment.
sorry, Ms. Hoffman, I don't know why my registrar is taking ages
Oh,
to.
I do apologize, and I'd moved on, Chair, I didn't realize. What was useful is that Ms. Kwinana read it and then gave me the confirmation.
Yes,
that
yes.
as the resolution reads,
Yes.
that the board had approved the contract to be awarded for those
Yes,
5
I
years.
might not have to look at
I
it. yeah.
certainly don't
Okay,
think you
no,
need to.
that-
Thank you.
Okay, let's move on.
So what that means is that you were involved in 2 decisions, one in your capacity at the SART board and one in your capacity at the SAA board, that generated revenue for JM Aviation. And we've looked previously at what that revenue looked like. It's about 75 million, even if you cut, let's say 60 million, if you take the 1.25 billion rather than the 1.5, and it's 6 million in the GPUs. So those 2 decisions generated revenue, let's say in about 60 million rand for JM Aviation. Do you accept that?
No, Chair. I wouldn't know how much revenue was generated. So basically, that would be based on the assumptions. So I cannot say with certainty that JM Aviation benefited on that, because as I was saying, the profit on GPUs, there were some issues in respect of the profits on GPUs, and the 5%, of AAR, I do not know what contract did they enter into, and therefore I would not be in a position to confirm the revenue of JM Aviation. They would be in a better position to confirm their revenue.
Okay. We had gone through all of this to lead up to this point, because understood you accepted 5% of 1.5 billion was 75 million. I'm going to change tack. Do you accept that these 2 decisions meant that SART and, well, it's just SART actually, SART paid JM Aviation money?
I don't know if SAT paid money to JM Aviation.
Well, you're actually right. SART paid money to AAR, which AAR then paid on to JM Aviation in terms of their joint venture agreement, which was part of the way in which they bid. Are you saying that you dispute that JM Aviation generated anything because of the business with SART?
I'm not disputing, Chair, but I'm saying I do not know. Those are the things that I cannot confirm.
I understand. It's the figures, is that right? But you'll accept with me that a bidder who gets awarded a contract generates revenue from the contract. Do you accept that?
Yes, Chair.
Thank you. Right. Now, from June 2016, your company, Zanospark, received money from JM Aviation and people linked to JM Aviation, like Ms. Hendricks, who you understood at the time was an employee. Do you accept that?
Chair, my company received money from JM Aviation from August 2016. Zanospark received 2 amounts from Ms. Hendricks. Ms. Hendricks, I did not know until this commission that she is married to Mr. Nzeko. Even with that, Chair, if you look at the procurement process, JM Aviation and Swissport had gone through the rigorous process, starting from the approval by CFST. And therefore, for these companies to be in the top 3. I really do not think that I would have influenced from the beginning up to the end of the process. And secondly, in the board, I am not the only board member of SAA Technical. There were other board members at SAA Technical. And therefore, there was no way that I would influence any of these contracts. And therefore, Chair, and another thing, when I was still at SAA and SAAT, I did not have a business relationship with VUYO. The business relationship with VUYO happened after I left SAA Technical.
So business relationship with?
With Mr. Nzeko.
Oh, okay.
Yes. It happened after I left SAA Technical, the business relationship. And so, Chairperson, to say that I influenced, maybe I may not put it exactly the way you said it, but to say that I influenced the process, I think at a cross-functional sectional team that is bid evaluation, there are about 15 or 16 people from different areas of SAA and SAAT, 15 people. And then from there, even if I can be so influential, and if I had influenced those people, they would also come to the Zondo Commission to say, I spoke to them, I spoke to them. So what I'm saying, Chair, the process that is being followed makes it so difficult to influence the process. It is the same with Swissport. We did not award that tender. What we were doing, we were regularizing the contract. How we regularized the contract from 2012 to 2016, that was on a month-to-month basis because it was never signed because of the disagreements between Swissport and SAA. So they were on a month-to-month contract. That caused a lot of uncertainty because Swissport is one of the major customers of SAA. If Swissport goes on strike, SAA would not fly. And therefore, Chair, also that process followed the rigorous process of FSTC. And that FSTC is even, you can't even say you will influence them because it depends who gets called at the moment, depending on what the tender is and who is playing which role. And therefore, Chair, let me repeat again, I do not sit alone in the board, Chair. Whatever decisions that we do is a board decision.
Ms. Kwinana, what was my question?
Remind me, Chair.
The question was, do you accept that from June of 2016, your company, Zanospark, received money from JM Aviation or people linked to JM Aviation?
I am saying, Chair, that money that we received, that is another thing that I should explain, Chair, again.
Yes, but let's start with, is it yes, you accept what the proposition that Ms. Hofmeyer is putting, or do you not accept it? Then we can talk about the basis for not accepting it, or if there is to be a qualification to saying you accept it. If we want to make progress and finish within a reasonable time, it will help if, as far as possible, crisp questions are answered with crisp answers. Obviously, I accept that sometimes there needs to be some qualification or explanation, but it will help progress if you are able to answer yes or no to a question that seeks that.
Chair, the reason why in this question, I am reluctant to answer yes or no, is because in previous hearings, Advocate Hofmeyer said, I accepted, I was involved in a corrupt scheme. I accepted bribes and kickbacks. That's what she said. And in fact, now her question will be, I don't know what will be the follow-up question.
Yes, but don't worry about the follow-up
fine.
question.
So-
You'll deal with it when it comes.
So
First, she just wants to find out, do you accept that your company received money from Ms.
JM Aviation or people linked to JM Aviation?
Yes.
maybe she should tell me, Chair, that I received money for what?
Well, that can come later, but if you did not, your company did not receive money at all, then there might be no need to go into for what. But if you say, yes, it did receive the money,
Yes, Chair, it did receive the money.
okay, all right.
Thank
Let's
you.
take it from there.
I'd then like to pick up just for a moment on something you did say earlier about that distinction that money before you left SART came from Ms. Hendricks, and it was only after you left SART that money came from JM Aviation. Do you recall drawing that distinction?
Yes, Chair.
Yes. It's a distinction that I confessed to Mr. Nzeku when he was giving evidence that I couldn't understand. You did watch his evidence, did you not? Or did you look at his transcript? Which was it?
I did. I looked at the transcript.
Right. So do you recall me raising that with him?
Yes, Chair.
Yes. Because you see, his evidence before this commission is that it was him, it was his investments, and he was simply asking his wife to make the payment, that first 2.5 and the 605. Do you recall him giving that evidence?
I will not say I recall him.
Okay.
I will not say I recall specifically that.
No, that's fine. Let me tell you, that is what, yes.
However, even if the money was coming from Mr. Nzeku, the money was not to my benefit. The money was for his
No,
investment. That is one. Let me finish. The money was for his benefit, not for my benefit. Yes, and secondly, there could be, like for instance, if there was. Let me talk about the disclosure and conflict of interest without being asked that, but I need to cover it. The money, the first money was paid on 1st of July. 1st of July, that was the first money. Now, assuming that it was Mr. Nzeku, or yes, assuming the worst case scenario was that it was Mr. Nzeku. Now, when would I disclose the interest? At SAA, there are two specific circumstances where we can disclose the interest. We have got annual disclosures. And if Zanospark is not there, that means I was not part of the Zanospark, but I don't want to go there. But what I do, I have got access to CIPC where all my directorships are there. I print that and send it to the company secretary. That is the annual disclosure. And then the second disclosure is when you see a pack in front of you, you going to the meeting, and then you think that your decision will be impaired here. When those monies, including the one that was put by Ms. Hendricks, when those monies were put there was no time where I would say, now let me disclose my interest, because the company that I am linked to, being Zanospark, is also doing the work with the company that we're doing work with, like SAA and Zanospark. So there was no circumstances like that. And therefore, Chair, the monies that we received, firstly, from Ms. Hendricks, whom I didn't know that she was with Ms. Nzeku's wife. We did receive it as a company. I agree with that. We also received monies from JM Aviation. Those monies were for forex trading. So to answer your question, yes, Zanospark did receive those monies.
Thank you, Ms. Kwinana.
But they were not for bribe and corruption and kickbacks, as you said it before.
Ms. Kwinana, at this point, I'm just getting confirmation that you accept that you received it. I do want to go back because you keep emphasizing that you only learned that Ms. Hendricks was Mr. Nzeku's wife in the evidence before the commission.
Yes.
But remember, we dealt with that the other day. You knew that she was linked to JM Aviation.
Yes.
That you knew, right? So when you received the payment on the 1st of July 2016, when you're still a director of SART and SAA, you know that Zanospark, your company, is receiving 2.5 million from a person linked to JM Aviation, correct?
Let me make one slight correction. Ms. Hendricks, I knew that she was a colleague of Mr. Nzeku. I don't know if she is linked to JM Aviation.
We'll go and get the transcript of the other day. You referenced particularly that she was employed, or I don't know if you use the word employed or accompanied at JM Aviation.
She was a colleague. She was a colleague of Mr. Nzeku. Which company, I do not know.
Well, we'll go
Because
back to the
another
transcript.
thing, Chair, Mr. Nzeku is involved, as I said before, is involved in many companies. So when he says Ms. Hendricks is a colleague, then, and in fact, even if she said, Mr. Nzeku said Ms. Hendricks is a colleague from JM Aviation, for the reasons that I have just explained, I really would not see anything wrong.
You wouldn't see anything proper. So then I was just going back to this change, right? It comes from Ms. Hendricks while you're still at the board of SART, but then when you leave, it comes directly from JM Aviation. And I was telling you that in Mr. Nzeku's evidence, I'd queried with him why, if it was his investment, that change needed to take place. It didn't make sense to me. And I actually said to him, in fairness to him, it starts to look like you're trying to hide who the real payor is by interposing somebody else when it's actually him, it's his money, and it's money owed to him by JM Aviation. And he didn't really give much of an answer to explain that. I want to put to you what occurred to me when I was looking at that change, preparing for your evidence. You see, remember right at the beginning on Monday, I'd asked you about your resignation on the 22nd of August, 2016. Do you remember discussing your resignation?
Yes, Chair.
Yes. You see, that resignation falls directly between this change. You see, until you resign on the 22nd of August, it's Hendricks paying money into the Zanospark bank account. But after the 22nd of August and you've resigned, it's JM Aviation paying into the bank account. Do you accept that difference?
I wouldn't know the internal arrangements that they have, Ms. Hendricks and Mr. Nzeku. And therefore, I will not want to comment as to whether the money came from my books.
Yes.
The two amounts came from Ms. Hendricks.
Yes, before you resigned.
Yes.
And all of the JM Aviation amounts
Yes.
come after you resign, correct?
Yes, but as I said, I wouldn't know their internal
No.
arrangement.
I accept that. I accept that. But what struck me as quite stark is that Mr. Nzeku says he's investing in Forex with you. He says it's his investments. But he uses his wife with the name Hendricks to send you the money, deposit the money in Zanospark before you resign from SART. And he then has no difficulty using JM Aviation after you resign from SART. And that coincidence indicated to me, and that is why I put it to you, that the concern about why he would use Hendricks before you left might be linked to the fact that no one would then, while you were there, be able to link the payment to JM Aviation, and that you were free after you left SART to get them directly from JM Aviation. Was that what was going on, Ms. Kwinana?
Chair, you said we cannot raise questions, but I'm thinking from the top of my head that if that was the case, if Mr. Nzeku wanted to hide that, wouldn't he continue to hide it under Miss Hendricks, or had they already divorced when now JM Aviation directly pay me? Because really, if he wanted to hide it, he could also have continued to hide it and use Mr. Hendricks. That's basically Mrs. Hendricks. Basically, that's what I'm thinking. But now, why would he change? Because now Miss Hendricks is the wife, and therefore there is nothing to hide in her being the wife. So what I'm saying is, if he wanted to hide anything, I would think that he could have continued as Miss Hendricks if Mrs. Hendricks' transaction is hidden anyway.
Well, Ms. Kwinana, you said earlier on, if I understood you correctly, you raised the point that you only received payment from JM Aviation after you had resigned, isn't it?
Yes, Chair.
And it seems to me that the point you sought to make was there was nothing wrong for you to receive money from JM Aviation after you had resigned. Is that not the position? Is that not the point you wanted to make?
Chair, even before I resigned, there was nothing wrong. There would be nothing wrong in me receiving the money from JM Aviation.
Yes.
The reason being that there is nothing in the SAA policy, and also even in government that I do business with, there is nothing wrong that says you can't do business. What it says is that disclose. And therefore, had I stayed at SAA, I would still do business with JM Aviation, but disclose.
But disclose and take part in decision making affecting JM Aviation.
No. What needed to happen is, if the submission comes and it has JM Aviation,
Would not take part in decision making, isn't it?
this is how it happens, Chair. When I see a company that I am doing business with, that I need to make a decision, I know you will come to NNS
Don't worry about what she will come to.
I know you will.
You will
come
deal
to
with it when it comes.
PwC and Gold. But what happens, Chair? When I see that there is JM Aviation that is going to be here and any other company that I am doing business with, I would disclose and say, I do business with this company.
And then proceed to take part in deciding in a matter involving them, or you then recuse yourself? Which one would you do?
It also depends, Chair. In this case, in the case of, can I say, make an example of these three companies? In the case of JM Aviation, where basically I know that Mr. Nzeku is a director here, and Mr. Nzeku is investing his money with Zanospark, the company that I am linked to, then I would recuse myself. In the case of me approving the audit fees of Ngonki and PwC, doing business with them on a contract by contract basis, which is normal, which I am not getting the money from Ngonki and PwC, but I am getting money from Prasa, I'm getting money from Transnet, I'm getting money from Postnet, then I would not recuse myself, because the decision to award us that tender is not dependent on Ngonki and PwC, and it's also not dependent on me. So I don't know, Chair, if this makes sense, because in the case of PwC, the monies that we received were the monies from Prasa. The monies that we received from Ngonki were the monies from Transnet, and therefore, Chair, there was no conflict of interest. And in JM Aviation, at the time, I was not doing business with JM Aviation. And if I was doing business with JM Aviation, I would have disclosed my interest.
And you would not have been entitled to take part in any decision relating to JM Aviation.
Yes, Chair.
Ms. Hofmeyer.
But Ms. Kwinana, the point that you keep emphasizing is exactly the one that troubles me, because it's precisely because the first two payments, as I understand your version, didn't come directly from JM Aviation, that you didn't have to make the disclosure, correct?
Not only that, but as I was saying again, even if the monies were coming from JM Aviation, I have stated the two circumstances where you disclose your interest, your conflict of interest. The first disclosure of the conflict of interest is the annual disclosure. The second disclosure, and the annual disclosure, we disclose it towards the end, the year end. That's the first disclosure. The second disclosure is when you have to make a decision.
Ms. Kwinana, you may have annual disclosures and whatever disclosures. The fact of the matter is, if a matter comes before the board of which you are a member that involves certain people or certain entities, which gives rise to a conflict of interest, you can't not disclose that there is this conflict of interest, and you can't take part in decision-making involving that situation where you have conflict of interest, isn't it?
That's correct, Chair.
Yes. Ms. Hofmeyer.
Yes, so it doesn't depend on the circumstances. Are you aware of the provisions of Section 75 of the Companies Act?
What does it say?
It's about directors and personal financial interests and when they must disclose and when they must recuse themselves. Are you aware of those provisions?
Whose personal financial interest?
No, I'm
Because
asking, are
in
you
the-
aware of the
because
provisions of
whose
Section
personal
75 of the
financial
Companies Act?
Whose personal financial interest? Because in the
Hang on, Ms. Kwinana. Just listen carefully to the question. Ms. Hofmeyer is asking you whether you are aware of Section 75 of the Companies Act, and you asked her, what does it say? She has now told you what it says. Go back to the question and say, yes, I'm aware, or not. No, I'm not aware.
I'm aware.
Okay.
Okay, so
But, Chair, I'm aware, but I don't want you to say. In fact, I want you to put it in your mind, Ms. Hofmeyer.
Don't deal with what she has not raised yet.
No, I want, Chair, I want to correct this. I want to put it in her mind that I did not have a personal interest. I did not have a personal interest.
Well, she said the act relates to personal finances, is that right?
Personal financial
Personal
interest,
finances.
Personal financial benefit.
yes. Interest.
I didn't, personal financial interest. Okay. I did not have the personal financial interest. What they are doing, they are investing in forex trading. I am investing for them. I do not have a personal financial interest. If I have the personal financial interest, I will only have the personal financial interest on maturing of when they say on this date, I want my money based on the agreement, then that's when I am going to have a financial interest. As I am sitting here, I do not have a personal financial interest, Chair.
No, Ms. Kwinana. They are doing business with you.
Yes, Chair.
That's good for you. You want their business.
Yes, Chair.
Actually, you'd be happy if they gave you more business.
Yes, Chair.
You are going to sit here, you can't sit now and make a decision that could disappoint them, because they might not give you more business in the future. They might even take away the business that is there. They don't have to wait until maturity. Right there and then, you have an interest in them continuing to give you business while you are faced with this decision that must be taken about them.
Yes, Chair. But remember that Ms. Hendricks.
So you do have an interest, because they are making an investment that may result in you getting money in due course, and you want them to keep this business with a relationship with you. Actually, you'd be happy if they could give you more business. So you have an interest.
Yes.
Yes.
Yes, Chair.
Ms.
But-
Hoffman.
Yes, Chair. I have an interest when they have put the money in my business. But for SAA Technical, JM Aviation put in money after I left SAA Technical. Let's go back to Ms. Hendricks.
Yes, no, let's not go back, because I've heard
Okay.
what you say.
Thank you, Chair.
Ms. Hoffmeyer,
Ms. Kwinana, I absolutely understand, but you'll correct me if I've got it wrong, that your version about why these payments are not suspicious at all, that came from JM Aviation and Ms. Hendricks, is because you did not benefit from them. Is that correct?
Yes, Chair.
We've just clarified with the chair that you did benefit in the sense that you benefited from their business. And I understand that that involves some remunerative consequence for you, correct?
That's fine. Let's agree. Let's agree that I benefited.
Right.
But when did I start to benefit? And when was I supposed to disclose this interest?
No, Ms. Kwinana, that's why disclosure is a little bit of a red herring, you see. The way that bribery and corruption sometimes takes place is it doesn't have to precede the decision-making. That might be too obvious a way to design the scheme. It doesn't matter at all that it comes later. If the people who are engaging in the bribes or the corrupt activity devise a very clever scheme that they're going to be benefits given by contracts being awarded, but they're going to be quite careful. They're going to make sure the money starts to flow only through people that won't make it obvious that there's a connection, and then later after you've left. That doesn't stop it being part of a corrupt scheme. The timing doesn't prevent it being part of a corrupt scheme. So your consistent emphasis about the fact that the money only comes in at a point when you'd already made decisions, or the money only comes in from Ms. Hendricks until you leave, I put it to you, is not an answer if the overwhelming rest of the evidence indicates that there was an arrangement that was reached in order to influence your decision-making at start. Do you have a response to that?
Where is this overwhelming evidence? Can I have access to this overwhelming evidence, Chair?
I'm
She
going
will
to take
point
you
it
through
out
it
to
now.
you.
Okay. So, your version previously has been you didn't benefit. Now you're accepting some benefit and then you emphasize time. And I say there's evidence there that suggests that there might have been a scheme. So I want to put all of that evidence to you, Ms. Kwinana, so that you have an opportunity to respond. The first is that Ms. Mamela, a person who I don't understand you to have regarded in any way suspiciously, unlike Ms. Sambo, who you've been very clear before this commission was a pathological liar in your view. Ms. Mamela, in an unguarded moment, in an email communication in 2017, referred to the fact that you, amongst others, tried to solicit a bribe from AAR. That is a first piece of evidence that suggests that there was bribery going on.
Sorry, can you start again? What is this piece of evidence? Ms. Sambo?
No, it's Ms. Mamela in a WhatsApp communication with Ms. Sambo, referring to the fact that she had knowledge that you were involved at a point in time seeking to solicit a bribe from Cheryl Jackson, who's associated with AAR. And I add that she's not a person that you before this commission has indicated should not be trusted, or you resisted the conclusion that she's a pathological liar. So I say that's the first piece of evidence. Do you have a response?
So your evidence is Ms. Mamela's WhatsApp. Let me just hear you
Oh, you want her
correct
to...
you. What is the evidence? The
Well,
evidence is
I
Ms.
can't-
Mamela's. The evidence is Ms. Mamela's WhatsApp. Is it what you are saying?
Yes, but I can't do it without your answer because the questions are going to follow depending on the answer. So can I have your response to that?
Mrs. Mamela's WhatsApp cannot be the evidence. I dispute that.
Right. Then you emphasize that there was a genuine business relationship between yourself and Mr. Nzeku and Ms. Hendricks, correct?
Yes.
Right. That business relationship is not supported by a single document that you can produce to the commission. And I want to couple that with the proposition that legitimate business relationships generate documents.
Sorry, Chair. Can you be slower? I'm
Sure.
writing.
Of course.
Today, I don't want to say I don't. I will have forgotten your question.
Of course. So it is the business relationship that you say existed between yourself and Mr. Nzeku and Ms. Hendricks has not generated a single piece of paper, a single document that you can place before this commission. And usual genuine business relationships generate documents. So I put it to you that the fact that you can't bring to this commission a document, you were summoned to produce these documents exactly 2 months ago, the 7th of September 2020. And we sit here today on the 7th of November 2020, and we have not a single document evidencing what you say is a genuine business relationship. And I say on the probabilities, that indicates there isn't a genuine business relationship. What's your response to that?
Much as I did not submit the documentation, Chair, because of the server, I would think that your investigators could have gone to Onero and find out what is there. And secondly, I did, as I said before, submit the documents to Mr. Nzeku, the statements, the annual statements to Mr. Nzeku. So it is not correct to say, of course, it is correct to say we did not submit the documents here, but the businesses that we are doing does have the documents, and Mr. Nzeku has also got the documents.
Can I tell you what the problem with that is? We've established that the servers were confiscated in April of 2019. On your version, you generate annual statements for each of your clients and provide them in January of each year. The confiscation of the server, Ms. Kwinana, is not a reason for you not to be able to produce to this commission your January 2020 investment statements. What's your response to that?
Chair, I submit the annual statements on an annual basis. I submit the December statements and submit them in January. That's exactly what I do.
Yes, so where are the January ones from this year? Why did you not respond to a summons? The consequence of failure to respond to it is that you commit a crime. And let me just be very clear, this point has been made repeatedly in correspondence with your attorney, where on each occasion there is an effort to avoid complying with the summons. The first effort was to take a service point, that it hadn't been properly served. When we produced the return of service, we then said, we remind you again, the law requires you 10 days from service of the summons to produce the documents or an affidavit. And since then, there has never been this document produced. It's a legal obligation on you, Ms. Kwinana, to do it. We have discovered through the evidence from Tuesday to today that the servers were confiscated in April of 2019, and you have still not produced the annual statements that you say are created in January of every year. We say that that is overwhelming evidence, Ms. Kwinana, that this is not a legitimate business relationship, because the justifications you give keep being pulled apart. Where is the January 2020 annual investment statement that a summons issued by this commission required you to provide 10 days after the 7th of September this year?
I've got the January statements, Chair.
Yes, but when you give it to us tomorrow, you may have fabricated it. That is the problem. Your evidence previously is that you didn't have it. And that precisely, Ms. Kwinana, is the difficulty.
I said, Chair, I submit the statements on an annual basis. And I said the last statement that I submitted was January 2020.
The question, Ms. Kwinana, which Ms. Hofmeyer has repeated probably more than 3 times, is you were required by way of a summons to produce it to the commission. Already the summons was served on you in September. Why did you not submit it if indeed you had it?
Chair, the statements, I have got the statements.
Why did you not submit it in compliance with the summons if it existed?
Chair, this information was required with a whole lot of other information, which basically went missing, like were taken with the server. So maybe...
Did it exist or did it not exist in September this year and in October this year? We are now in November. Did it exist during these 2 months?
Yes, Chair.
Why did you not then produce it to the commission?
The commission, Chair, requested the whole lot of other information which I do not have.
Yeah, but you had this one. Why didn't you produce this one?
No, Chair, I was thinking that I needed to produce the whole bunch of the information that was required.
No, Ms. Kwinana, that can't be true. That can't be true. If you get a legal document, a summons, saying produce 5 documents to the commission, bring 5 documents, and you know that you don't have 3, they don't exist, but you have got 2, you tell me that you wouldn't come to the commission and say, I've only got these 2. You would withhold these 2 because you don't have the 3. Can't be true.
That's an omission on my part, Chair.
Sorry?
That is an omission on my part.
Yeah, but it's something so obvious, Ms. Kwinana, it can't be true. What anybody would do is to say, Commission, I will give you what I have. This is what I have. Anything else that you wanted from me, I don't have. That's what everybody would do. Can't be an omission. You are being asked to produce 5 documents. You don't have 3, they don't exist anymore. You've got 2. You can't sit back and say, I'm not going to give the Commission even these 2 that I have. It wouldn't make sense, would it?
Now that you say that, Chair, sorry.
Yeah, the problem is, on Tuesday, your version was that you don't have the January 2020 statements because they were taken by the server. So, Ms. Kwinana, we're going to argue in due course that you are a dishonest witness. You are a witness who turns the facts each time they become difficult for you. Ms. Kwinana, the next bit of evidence is that your explanation for the way in which you were conducting this business to try and get a response to the fact that you've produced no documents under the summons relies on a remarkable confidentiality policy that you say exists in a business, which, if I understand it correctly, means you could never email your clients. And I want to put it to you that in 2020, to be conducting an investment business involving forex trading and having a confidentiality policy in place that never allows you to email a client is nothing short of preposterous. What's your response to that?
Our policy, Chair.
Ms. Hofmeyer?
Chair, if I could just take a moment. Oh, yes. One of the last things we did on Tuesday was we were looking at not only the 4.3 million that you got from JM Aviation and Ms. Hendricks, but also that extra 800 and a bit thousand. And you gave us an explanation that it came from Janipath, a supplier to SART, because of some quite complicated, I have to say. It took me a while to follow it at the time, but I think I've got it now. The version is Janipath paid that amount into Zanospark because you had engaged Mr. Kolisi. Is that correct?
Yes, Chair.
Yes. And who was Mr. Kolisi?
Was the lawyer.
A lawyer. How did you know him?
I know him from SAA.
Yes, because Mr. Kolisi was one of the people that SAA contracted to run Dr. Dawa's disciplinary process, isn't he?
I don't know which contract did run Dr. Dawa, because I'm sure that was not included as part of the board.
Yes, it wasn't included in part of the board, but you attended a meeting with Mr. Kolisi in advance of Dr. Dawa's disciplinary hearing to discuss the hearing. Do you dispute that?
I dispute that.
Okay, let's get the email. Let's get the email. Could we please hand up as I have to get track on my exhibits. Let me hand them in first, Chair. There are 2 documents. So if I can ask, maybe Andrew, do you mind helping me? We'll give to Ms. Kwinana. Andrew will give to Ms. Kwinana. Yeah, it's the 2. Thanks. I just need to make sure that we give it the correct exhibit number. There are 2 documents, Chair. The first is an email dated Friday, 4 March 2016. You might see that. And then the second document is a confirmation of acceptance of the meeting that's being referred to in the first email. So if we could enter as exhibit DD 33B.24, the email of 4 March 2016.
Sorry, did you?
34B.24.
That is the one, or the one from Mr. Peter.
Lester Peter, yes, correct.
The email
34, I
dated
don't have
4 March 2016
Sorry?
from Mr. Lester Peter to Carol Chinjeke will be admitted as Exhibit DD 33B.24.
Thanks. I just want to clarify for Ms. Kwinana, because I think she was just momentarily confused there. So it's not in the bundles, it's because I've just handed it up. So the first one is DD 33B.24, and then Chair, if we could make the second document, which is DD 33B.25, and that's the acceptance of a meeting invitation dated 4 March 2016.
Then add the document purporting to come from Ms. Yakhe Kwinana at yakhe@kwinana.co.za dated 4 March 2016 at 14:20 to Carol Chinjeke with the subject accepted consultation with external lawyers on Masimba DC is admitted as Exhibit DD 33B.25.
So, Ms. Kwinana, what you'll...
Chair, my apologies, Chair, my hand was up. I just wanted to point out two omissions. The first one, I haven't been given as the legal representative
Oh,
documents.
I'm
I do apologize. Can I
I'm
just
sorry.
explain why, Ms. Mbandra? For the last few days, we've only had 2 people in this room.
Yes, and
So I'd
then-
forgotten to do the third. There you go.
Yes, and then the other difficulty I have, Chair, I don't know what your ruling will be. Generally, before the witness is asked on these documents, we are supposed to see them and consult on them. So if maybe we can be afforded an opportunity to take a look, I don't know when are we supposed to get the break, Chair? So that these documents that Ms. Hofmeyer is admitting into evidence, which we haven't seen, we can take, we won't be long, we can take a look at them, and then the witness can be prepared to answer.
Yes, obviously this arose because there was a denial.
Exactly.
Ms. Hofmeyer, what do you say to that request?
Chair, the challenge, I'm just going to put it on the table, is we will argue in due course that the weight that should be given to Ms. Kwinana's answer after she's adjourned to consult with her lawyer about the answer might be of less value than an answer that she gives without that consultation. I simply place that on record. I make no submission about whether that should take place or not. If Ms. Kwinana would feel more comfortable discussing this with her lawyer, that should take place.
Ms. Mbandwa, what do you say?
Chair, can I say something with all due respect? I must object to this expectation that Ms. Hofmeyer has. It is the expectation that this witness is not entitled to proper consultation. I do not understand the rules of the commission to be like that, because every time we are raising either a point or we are explaining a right the witness has, it is as if we are doing a wrong thing. And we really are happy with the way the chair has treated us today, and even Ms. Hofmeyer. We don't want to end in an altercation as we normally do.
Well, you see, as far as possible, while a witness is being questioned, it's preferable that he or she should be able to just answer questions. It's different if there were consultations before, because obviously there would have been consultations before the witness took the witness stand. But what Ms. Hofmeyer is saying about what she will argue. It may be that it's something that she wants to argue. Do you insist on consulting with the witness, or are you happy to see whether the witness has any difficulty in answering?
To be blunt, Chair,
Yeah.
personally, I really don't care what Mrs. Sophia argues. Because even before this witness came here, before she had a chance to examine this witness, she argued that she is a corrupt person. I think we have already traversed that. So I think it would be remiss of me as a legal representative to, at this late stage, worry about what Ms. Sophia is going to argue. With all due respect, she can go argue whatever she wants to argue, as long as we get opportunity to look at documents. For me, that
Yes.
would be the best option, Chair.
Okay, let's take a 5 minutes break for you to consult then, and then we will resume. Okay, we adjourn.
All rise.
Chair, that Mr. Kolisi was involved in the disciplinary process for Dr. Dawa. Do you now accept that you did know that? Oh, you'll need to put on your...
Chair, I note that I was CC'd in this email. I still do not remember me having attended the meeting. I, however, may have attended the meeting because I was the person who lodged a complaint. However, considering that I do not remember well this meeting, I would appreciate if I could have the minutes of the meeting.
We don't have those minutes. We only have your invitation, absolutely. You accept that you got the invitation and Mr. Kolisi is also copied on it, correct?
I may not necessarily have received the invitation, Chair. In many emails that you have here, most of them would be received by Lana, my PA. So it could happen that also this one is the one when she looked at my diary and accepted it. That's why I was saying I can only confirm. I'm not saying I was not there, but I'm saying I do not remember. And therefore, I would be assisted by the minutes.
Did you say to her that she could do that? She had the authority to do that? That if there was an invitation for you, she should look at the diary, and if it was open, she could go ahead and accept without you having told her that, instructed her to accept?
Most of the time, she would do that, Chair.
And that's how the two of you operated?
That's how we operate.
Mm-hmm. Okay.
So do you persist in your version that you didn't know that Mr. Kolisi was running the disciplinary for Dr. Dawa?
No, Chair.
No. And the fact that you accepted a meeting invitation to go and consult with them the week before Dr. Dawa's disciplinary process took place, you still maintain you had no knowledge that Mr. Kolisi was involved in that process?
Yes, Chair.
We'll argue...
I'm sorry, Ms. Hoffmeyer. Wouldn't your PA, if she accepted an invitation in terms of the arrangement that you say you had with her, wouldn't she take the earliest opportunity thereafter to tell you about such an invitation and the fact that she had accepted it on your behalf?
She does that, Chair.
She would do that?
Yes.
Okay.
You fairly said, Ms. Kwinana, that you were the person who lodged the complaint against Dr. Dawa.
Yes, Chair.
And are you aware that a disciplinary process was run?
Yes, Chair.
Yes. And did you follow up on that process?
No.
No, because you were very, let me put it to you for your comment. When I read that 9th of October 2015 email that you sent, you asked for the chair's intervention because you took the issues very seriously, did you not?
Yes, Chair.
And notwithstanding that, are you saying you never at any point followed up about the process and what was happening with it?
No, Chair.
No.
In fact, it's the same thing as the contracts. We don't follow up what happened after we have approved. Yes. And therefore, also, when the disciplinary process takes place, you don't follow up what is the outcome of the disciplinary process, because the outcome of the disciplinary process, how it went, depends on the line manager of that person.
And
But where you lodge the complaint, you are therefore the complainant, I would expect you to have an interest because in finding out what's going on with that process, because you would have been feeling very strongly that this person should be disciplined. If one looks at that email that Ms. Hofmeyer refers to, you were feeling very strongly about what you considered to be unacceptable conduct on Dr. Dawa's part.
No, Chair, after I lodged a complaint and left it with the people who are supposed to attend to it, I really do not see, even in my office, for instance, I really would not see the need for me to follow up as to what happened. Even though our office was much smaller, but still it's because I do trust the process. And therefore, how the disciplinary process goes, I really, including the CCMA disciplinary process, so how they go, I really do not follow up.
Except, Ms. Kwinana, that is so. Why would the head of procurement at the time, Lester Peter, be inviting you to a meeting the week before Dr. Dawa's disciplinary was scheduled to start to say the following? As discussed, the legal representatives of SAA have agreed to meet the witnesses on the 7th of March 2016. Kindly schedule an appointment inviting all copied here too for 10 a.m. The consultations will be held at the venue where the inquiry would have been held on Monday, Tuesday. If you have no involvement, why would you be invited to this meeting?
This email, Chair, is addressed to Carol. I am only CC'd here in this meeting. And I have said, maybe the reason why I would be invited, I don't know why I was invited, but I'm saying, Chair, maybe the reason why I would be invited is because I am the one who lodged a complaint.
Yes, it seems logical to me, actually. It seems strange not to expect that the complainant would be expected to consult with the lawyers who would who would represent SAA. So the approach you take, which suggests that you had no interest, seems strange to me for a complainant, because I would expect that the complainant would be one of the people that the SAA lawyers would want to consult with and take a statement from, and that in all probability the complainant might be called to give evidence at the disciplinary inquiry.
Yes, Chair, I would have an interest. And maybe that is the reason why I was copied here. But however, Chair, you know, much as I would be very angry, as I was angry in the letter, for me, I know that that's basically not personal. I have stated my case, and then the people should deal, the people who are supposed to deal with it should deal with it. And with me, it just ends there. So basically, after 2 weeks and 3 weeks, I wouldn't be as angry as I was and want to find out what really happened. No, that is not me, Chair.
Well, on Monday or Tuesday, whichever day you gave evidence about this, you said you were indifferent to Dr. Dawa, and I think Ms. Hofmeyer, and certainly I said your email where you were complaining about him didn't seem to reflect an indifferent attitude towards him, and it seemed to reflect a strong negative feeling towards him. You now say you were angry. Can I accept that you accept that you were angry as a result of what you believe he had done?
Let me put it in context, Chair. On Monday or Tuesday, I said there will be differences between a senior and his or her junior, and vice versa. And those differences, it doesn't mean that they cannot be there. They are bound to be there. They are acceptable. I would think that they are acceptable in any organization. There is no way that two people will not have differences. But that doesn't mean that when I raise my voice or when I am angry at that point in time, I will always be angry. I will be angry after 2 hours. So maybe the indifference, I was putting the indifference in that context that, but I remember very well that I said there are bound to be differences between the two people.
Well, the suggestion was that as you wrote that email, you must have had very strong negative feelings towards Dr. Dow. That was the point. Not 2 hours later, not 3 days later. And as I understood your evidence, you were saying, no, that's not the position. I was indifferent. That was how I understood your evidence.
Chair, I wouldn't say I was indifferent. Of course, I was angry. And as I said, it is normal. You cannot laugh.
Yeah, no, I don't want you to go back. You have said that point quite a few times. But I think what now you say seems to me to be inconsistent with what you said either on Tuesday or Monday. Because on Monday, you maintained that that email did not reflect that you had strong negative feelings towards Dr. Dow. And I had to go back to the email and read it to you, or at least certain portions of it, because I couldn't believe that you could say you were indifferent to him when you wrote that email. But let's move on. Okay, Ms. Hofmeyer.
Thank you, Chair. Ms. Kwinana, there has been evidence, which I'm going to come to in a moment, Chair, because I neglected to do something late in Ms. Mieni's evidence yesterday that I do just need to ensure that we enter into the record. But what I would just want to understand from you, Ms. Kwinana, is were you at any time during Dr. Dawa's disciplinary processes alerted to the fact that the head of employee relations at SAA at the time had serious misgivings about how that process was being conducted? Did that ever filter up to you?
No, Chair.
No. Thank you. Chair, my error was yesterday, I referenced this in Ms. Mieni's evidence, and I'm not going to take Ms. Kwinana to it because Ms. Mieni is not evidence that she could have been aware of. She was actually anticipated to conclude her evidence before Ms. Mieni, so please just rest assured, we're not going to go there. But I, overnight when I was preparing, realized I'd forgotten to ask you to enter that affidavit into the record. So I wonder if we could just do that now for housekeeping purposes.
Yeah, let's do that.
Thank you. All that you will, it's not even probably necessary for you to have it in front of you. It's literally, well, you might want to see the date, etc. Should I hand it up? It's DD 34B. It's actually, Chair, an affidavit prepared in response to your request after Dr. Dawa's evidence. Remember,
Yes.
you raised the issue, well,
Yes.
what happened with the disciplinary process?
Yes,
Can you
yeah.
give me a full account? And so
Yes.
this was prepared by the head of employee relations pursuant to that request. So I
Okay.
just want to be sure that the record is complete.
Okay.
Oh, page 1719, which is under tab 32.
Should we also go there?
Ms. Kwinana, we're literally just doing this for record purposes. I'm not intending to take you to it. 1719, under tab 32. So, Chair, this is an affidavit prepared by Mr. Lawrence Daniel Erasmus, and it is, sorry, it's just sometimes difficult to find the end of it because he actually cuts and pastes emails in the
Yeah,
text
no,
of his...
that's what's confusing me. I'm trying to see the
Find the
end of
I know.
the affidavit.
Apology. Oh, there. Sorry, Chair. It's at page 1793, and it's an affidavit deposed to on the 17th of February 2020.
Okay, have you established where it ends?
Yes, 1753.
1753. Okay, all right, yes.
And if this could be entered as exhibit DD 34B.32.
34B point
32.
The affidavit of Mr. Lawrence Daniel Erasmus, starting at page 1719 of bundle DD 34B, is admitted as exhibit DD 34B.32.
Thank you. Ms. Kwinana, whatever we in due course make of the question whether you were aware that Mr. Kolisi was a service provider to SAA at the time, the evidence of Dr. Dawa previously is that he did run the disciplinary process. So as a matter of fact, he was a service provider to SAA at the time, and he was somebody with whom you were also transacting through your business. Isn't that right?
Mr. Kolisi was my client, or is my client. And I am transacting with him. And it boils back, Chair, to the processes. I never signed a single contract that involved Mr. Kolisi. There was not a single contract that was brought before me for Mr. Kolisi. And therefore,
Of course, board members don't sign contracts, isn't it?
Chair,
Board members don't sign contracts, do they?
even the approval, Chair. I never approved a single contract pertaining to Mr. Kolisi. It's also the same as Ms. Nobaka's company. I never signed a single contract of Ms. Snowbak.
Yes,
And-
Mr. Kwinana.
Yes. And in fact, if, for instance, in my business, which I would think that would be unfair if the commission would say, I must not enter into business relationships with people, in this case, example of SAA. I must not enter into a business relationship with the people I know, because that would mean that I would not be entering into a business at all, because as an auditor, Chair, I audit the whole lot of companies. When I was an audit,
Yeah,
I
okay.
audited.
Okay, Ms. Kwinana, I think we may be veering off. You may be veering off from Ms. Hofmeyer's question. Ms. Hofmeyer, is that still in line with your question?
No, what I was asking was whether Ms. Kwinana accepted that at the time she established a business relationship with Mr. Kolisi, he was a service provider to SAA. That
Yes.
was all I wanted to get her
Yes.
response to.
So don't worry about what you think she may ask later. Just respond to that question.
Chair, these are the questions that do not only need a yes or no, but I need to explain. I will say,
But start by saying, yes, I did, or no,
Thank you, Chair.
or no, I did not.
I knew. And I am saying, Chair, I never saw a single approval for Mr. Kolisi on my desk.
Yeah.
And therefore there would be no conflict. And I am saying, Chair, if I am not required to do business with the people I know, then that is a problem. I have a problem with that.
Yes, wait for her to indicate if she says there is a problem with the fact that you had a business relationship with Mr. Kolisi, and then you can deal with that when it arises.
Thank you, Chair.
Chair, we are at the lunch break time. We did take 2 breaks earlier, but we haven't taken a full break.
Yes.
And this has taken much longer than I anticipated.
No.
So I'm anxious about being able to navigate how we take things
Yes.
forward.
Well, things are not moving as fast as we all want. What's your estimate of how much more time you need, given the hazards and risks of
About
us
45
taking
minutes.
longer than you may estimate?
45 minutes.
Yes.
30 maybe. It's just if we could get the answers without the anticipation of the next, it might go a bit
Yes,
quicker.
might make
But
things go
of course,
quicker.
any explanation that we want
Yeah.
to give must be given.
Yes. There are 2 or maybe 3 possibilities. One, we could continue until you finish and then take a break then, so that when we come back, it's re-examination. Another one is that we could take a break now and then come back and you continue. And within that, we must think about maybe a shorter break than an hour. What do you say?
Chair, I failed to take advantage of the previous 2 breaks, so I would benefit greatly from a comfort break now. So for me, it would be better if we could break now. Yes.
Okay, Ms. Mbanjwa, what do you say?
No, to be honest, Chair, I agree with either. That is not the reason why I was raising my.
Oh, I didn't see your hand, yeah.
Yeah, no, yes, I was just raising. Now, what I wanted to ask, Chair, is because you had said you would give me an hour to re-examine. I was also thinking that maybe I don't re-examine and we don't come back. I just give written submission of the points which I want you to take note of.
Okay.
If you are comfortable with that.
Okay, no, I'm comfortable.
Yes.
I'll be comfortable. In which case, that would help.
It would indeed.
That would help quite a lot. But because you would like to take a break now, I think let's take a break now. But maybe, is it fine if we make it 30 minutes or 45 minutes?
Absolutely, absolutely. From my side, certainly.
What, 30, 40, 45 minutes? Yes. What do you say, 30 or 45 minutes?
30 would be adequate, Chair,
30 would be
depending on you.
adequate.
Absolutely.
Yes. Okay, all right. Let's make it 40 because I have to
Certainly.
travel.
That's what I was worried about. When I said 30, I thought that would be far too short, so.
Okay, all right. Let's make it 40, and that will mean we go out to, I think, 10 to
Indeed.
2. Yeah.
Thank you, Chair.
We'll resume at 10 to. We adjourn.
All right.
management companies, capital market companies, and forex brokers.
Sorry, so we're at cross purposes. You're not reading from the FICA Act, are you?
What does FICA Act say?
It says something different to that. What are you reading from?
I'm reading my notes, which says entities that are regulated by Financial Sector Conduct Authority Act.
Yes.
If I am not reading from FICA, can you read the entities that are regulated by Financial Sector Conduct Authority Act according to what you have?
No, you see, Ms. Kwinana, what's important is what you understand, right? I understand you to say that you had taken the view in your Zanospark business that you don't need to comply with FICA. Is that right?
I don't need to have a license.
No, it's a different matter. We were talking earlier about FICA. Remember, I drew the distinction. I said to you, I know that you take the attitude that under the legislation regulated by what is now the FSCA, this morning when you said
Say, am I supposed to comply with FICA or say know your client? Know your client would be to have the ID of my client. I would have to have, in fact, I've said this before, I would have to have an ID of my client.
Okay. From what you say, it seems to me that you are not in a position to say you know what FICA requires and whether its requirements apply to your business. You have an idea of what you think you are supposed to do or what you prefer to do, but whether that is what is required by FICA or not, you don't know. Is that right?
I know a little bit, Chair.
You know a
Let me
little
tell
bit.
you what I know.
Yes. Okay, Ms. Hofmeyer, maybe you can take it from there.
you haven't been conducting your business in a way that is compliant with FICA, have you?
That is not correct, Chair.
So can I just understand your answer is you have been conducting your business
Yes.
in a way that is compliant with FICA.
Yes.
Is that correct?
Yes.
You're sure about that?
Yes.
Yes. Did you receive at any point legal advice about what FICA requires of you?
I don't need any legal advice in respect of that.
You don't
Okay.
need it.
Yes.
So.
You didn't get it.
In other words, you did not seek or receive legal advice about what FICA requires, is that right? Is that right?
Chair, I have been writing exams, FSCA exams, I don't know how many times.
Yes, but Ms. Kwinana, just listen to the question and answer the question. Ms. Hofmeyer asked you whether you received legal advice about what FICA requires, and you said you don't need it. Now, that's not an answer. The question is whether you received it or not, and the answer will either I did not receive it or I did receive it.
I did not receive it, Chair.
Sorry?
I did not receive the legal advice, Chair.
And I understand the reason you gave is because you don't require it. Is that right?
Sorry?
You didn't see the need for legal advice.
Yes.
Yes, because you yourself have been able to determine
Yes.
what the requirements of FICA are, correct?
Yes.
Yes. And again, you said, so you do conduct your business in a way that's FICA compliant,
Yes.
correct? Excellent. So if that is so, why have you not taken efforts to keep your records for 5 years as required by FICA? All the records of your clients.
Chair, the issue of the server was beyond my control.
No, it wasn't, Ms. Kwinana, because your evidence on Tuesday was, it was a server that was initially contracted for Kwinana and Associates. You then said Kwinana and Associates went under. Remember, Kwinana and Associates is your former company, correct? Say yes, please, just for the record.
Yes, Chair.
So it went under. There was a huge liability. Zanospark took over the server. Zanospark was working on credit for a while, you said. And then you said Zanospark didn't have the money to make good the Kwinana and Associates debt. And that's why it was confiscated. Do I have your evidence correct?
Yes.
Yes. You see, the problem with that is if Zanospark is required to be FICA compliant, one of the obligations under FICA is that all records of the business need to be maintained for 5 years. And so you were legally obliged as Zanospark to ensure that you paid that debt and you kept that information, but you elected not to. That is not in compliance with FICA. Do you have a response to that?
Which information that is required from FICA, that when FICA comes and audit us, I will not have. Let me tell you, the ID documents, I will have that. The proof of residence, I will have that. And therefore, it will not be difficult for me to reconstruct that information, despite the fact that I do not have a server.
But why would you have it if all of your documents are on the server that you couldn't provide to the Commission, but there's some documents that you will have?
I said, Chair, it will not be a problem to reconstruct them. Also, Chair, if you want me to reconstruct.
If the legislation says keep the records, you say you don't mind not keeping them because if and when they will be required, you will reconstruct them. Is that compliance with the legislation?
I don't know in terms of compliance, but let us also again look at practicability thereof. The server was confiscated. That is one practicability. Even if I wanted to keep them, I would not be in a position to keep them, but I will be able to reconstruct them. What happens, for instance, if the house or the office burns down and you did not have an off-site backup, then that would also be another reason why the information may not be kept. And therefore, There are reasons, and in fact, even when FSCA would do the audit, that would depend. They would treat the case on a case-by-case basis, so to say. And therefore, Chair, the fact that I do not have the documents because my server was confiscated, there was no way that I would be in a position to have those documents. However, I would be in a position to reconstruct them.
Ms. Hofmeyer?
No, Ms. Kwinana, the point, you keep saying you were not in a position to have the documents. The reason that the servers were confiscated was for non-payment of a large debt. Zanospark was using the servers. Zanospark made an election not to pay that debt, to retain the documents that the law requires Zanospark to maintain. Do you have a response to that?
Not to make an election, Chair, but inability to pay and service that debt.
Why couldn't you take some of the millions that are being invested in your company?
Those millions are not mine, Chair. They are for the investors.
Yes. Well, Ms. Kwinana, we've dealt with that aspect previously. Let's go to the slip-knot agreement, Ms. Kwinana. You'll remember the do you remember the slip-knot agreement? That's the one entered into with Ms. Mamela. Sorry, I realize you have lots of slip-knot agreements. I only have one that I focused on, and that is the slip-knot agreement that you entered into with Ms. Mamela. Do you recall that?
Show me, Chair, where is it?
Okay, so that you'll need DD 25A for, and it's page 370.
Sorry, DD?
DD 25A.
This is DD 25B.
Page 370. And please feel free just to remind yourself, it's not a long document, it's 370 to 374.
Yes, Chair.
Do you recall this agreement?
Yes, Chair.
Now, this is an agreement which Ms. Mamela testified had been drafted by Ms. Mbanjwa, your lawyer today. Do you confirm that?
I can't confirm, Chair. She is here. She can confirm if she drafted this or not.
No, she's not the witness. So the question is, do you recall that Ms. Mbanjwa was the drafter of this agreement?
No, I don't recall.
You don't. And do you remember when you see a transfer, it indicates that the transfer of the property, sorry, this is at page 371, clause 3. Under 3 there, transfer, it says the transfer of the property shall be effected by the following conveyancer. That's a reference to Ms. Mbanjwa's firm, is that correct?
Yes, Chair.
Thank you. But you don't recall who drafted this, is that right?
No, Chair.
Do you recall its conclusion? You see, what was interesting is it seems as though it was concluded and signed, if you go to page 373, on the 21st of April 2015. Do you see that?
Yes, Chair.
Can you confirm that that's your signature for seller on that page?
Yes, Chair.
And then if you go over the page to 374, it was signed on the 21st of April 2015, and Ms. Mamela has confirmed that that's her signature as purchaser. Do you see that?
Yes, Chair.
Now, it was witnessed by what appears to be the same signatures, so that's why I asked Ms. Mamela about how this had come to be signed, and she indicated that you signed it together in each other's presence. Do you confirm that?
Yes, Chair.
Yes, and she said that that took place at Ms. Mbanjwa's offices. Does that help refresh your memory?
Pardon?
She said that that took place at Ms. Mbanjwa's offices. Does that help refresh your memory?
No, Chair, I don't know.
You don't know. So you do recall that you were together, but you
Yes.
just don't remember where you were?
I don't know where were we.
Okay, understood. All right. Now, this is quite an important agreement insofar as Ms. Mamela's explanation for the 2.5 million rand that was used in part to purchase her Bedford View property. So can you just maybe tell me what happened between the two of you in relation to this agreement? Why did she enter into it? What were your discussions about it?
This property, Chair, is a farm in East London. And we had been trying to rezone it. And it has been taking long for us to be rezoned. It's 8.5 hectares. We have been trying to rezone it since many years, I think maybe since 2007 or so. Yes. And the Buffalo City municipality has not put the services in that area. It's not far from the airport. So the Buffalo City has been promising to put in services, and therefore it has been in the process of rezoning for a long time. And then
That would have been to rezone it and make it what?
residential.
Presently, what is it?
It's a farm.
Oh, okay, all right.
It's agricultural.
Agricultural, okay.
Yes. So we decided that we need to sell it. And in fact, we did go to the Buffalo City to try to get them to sell it, to buy it. So when I was talking about this with Ms. Mamela, she saw a huge opportunity. And then I told her that we are selling it we are negotiating with Buffalo City, but Buffalo City is not coming to the party. And then she expressed an interest in it. And it is for this reason that we said, okay, if you want to buy it, then you can buy it. Although I do not know when the zoning will be finalized, when the proclamation is going to happen. And therefore, it is for this reason that we decided that she wants it, let me give it a try. In fact, it's a farm that I really wanted to get rid of it. We only got the eviction notice about a month ago today. So it shows how we have been struggling with this farm. But in the end, we did get the eviction, final eviction notice will be awarded on the 25th of November this month. So basically, this farm has been having a lot of challenges. Now, recently, the reason why we have got the eviction is because the illegal occupants did occupy this farm. So basically, that's why we wanted it to be rezoned as soon as possible so that we can do something about it or sell it as soon as possible.
Why did Ms. Mamela want to buy a agricultural farm in East London that was inhabited by unlawful occupiers?
No, at the time, it was not inhabited by unlawful occupiers. That's number one. Number two, she was looking at it when it is subsequently proclaimed,
Right, you mean rezoned?
rezoned up to the proclamation.
Yes. So she was keen on it, anticipating its proclamation, right?
Yes, Chair.
Yes. And her evidence previously was that, well, she was presented with evidence that said she didn't have available to her 2.8 million, despite that being the purchase price. Why did you arrive at this purchase price? Did she share with you that she didn't have 2.8 million available?
No, she didn't say she doesn't have the 2.8 million available. However, I did indicate to her the challenges that I have. And I said, I do not have the exact time frame as to when is the rezoning going to be finalized, in view of the fact that the services are not yet even there, and therefore it may take some time to be to happen.
Yes, but what then happens off the back of what you've described is you conclude an agreement that on its face says that she's liable to pay you a full 2.8 million and makes no reference to this proclamation being a condition of the agreement. Why wasn't that put in the agreement?
We both know that that is dependent. That was dependent, not necessarily on the proclamation, because the other thing that she could do, when she has money, she could just get it transferred to her even before the proclamation happens.
So that's just some independent understanding the both of you had that was not recorded in this agreement, is that right?
Yes, Chair.
Why didn't you seek to protect each of your rights under the agreement? Because, speaking for myself, reading this, you could have tomorrow demanded 2.8 million from her. And you could have forced her, and she wouldn't have been able to resist because there's no condition attached to the proclamation.
No, Chair, we did not even see a need for that, because she knew exactly what I was selling, and that's why basically I would also not be in a position to enforce some conditions.
So would it be fair to describe it as a fairly loose arrangement?
It's not that fairly loose, Chair. This agreement, we were happy with it.
You were happy with it.
Yes.
It doesn't record, can I put to you, what you've described your actual agreement to be. It doesn't record in its terms what your actual agreement as you've described it to me to be. Do you accept that?
That's fine, Chair, but me and her were happy with it.
Did you communicate your requirements to the lawyer who drafted this agreement?
No.
No. Who drafted it?
I don't even know.
You don't know?
Maybe, I don't know, but maybe Mhlambi ulindele.
Well, do you have any reason
don't
to
know.
dispute Ms. Mamela's evidence that Ms. Mbanjwa drafted it?
I did not dispute it. I said, I do not know.
No, indeed. I'm just checking if there's any reason you would have for disputing Ms. Mamela's recollection that Ms. Mbanjwa drafted it.
No, Chair.
Okay, so in Ms. Mamela's evidence recently, I put to her various features of this agreement that I said, based on the evidence that we've seen and its terms, indicates that this is not actually a genuine agreement, that this wasn't an agreement that was entered into between you and her on the 21st of April 2015 at the offices of Ms. Mbanjwa. And I'd just like to tell you what those features were, and then I'm going to ask for your input on a few others. You see, Ms. Mamela is married in community of property. Ms. Kwinana, what marital regime applies to your marriage?
I would rather not disclose that, Chair.
Are you aware that people married in community of property require the consent, written consent of their spouse to enter into any transaction of this nature?
No, I'm not aware of that, Chair. There was really no need for me to go and check that.
There wasn't. So if you're married in community of property with your husband, have you ever purchased property with him?
Sorry, what's your question?
Have you ever purchased property with your husband?
Yes, I did. And I did purchase a property with my husband. I also did purchase a property alone.
Now, I'm interested in the one with your husband. Did both of you consent to the agreement?
What does that mean? To say
In
we
writing, you say
agree?
you agree, yes. Because it affects your joint estate if you're married in community of property.
Sometimes I would purchase a property with my husband and then he gives me the authority to sign. And therefore I would sign
No,
alone.
that's fine, as long as there's a written recordal of his consent to give you authority to sign. So have you always had that from him?
No, sometimes I sign without the authority.
When you're buying a property with him?
Oh yes, it does happen.
It does. So when you were putting this agreement together, did no one, the lawyer, we've now established you can't dispute that it was Ms. Mbanjwa, did Ms. Mbanjwa ever inquire as to Ms. Mamela's property regime? Because it's a requirement that if she was married in community of property, that she do so with her
You mean marital, you said property regime, I think.
property, sorry,
Marital regime.
marital regime, indeed. Was any inquiry made of Ms. Mamela about her marital regime?
By whom?
By the lawyer, Ms. Mbanjwa, who drafted this agreement. Do you recall that?
No, I wouldn't know. Ms. Mbanjwa can answer for herself.
She's not on the stand today, so that's why I'm
So,
asking
no,
you the
I wouldn't
questions.
know.
You
I
wouldn't
wouldn't
know.
know, Chair.
But as the seller in a genuine agreement, do you accept that if your purchaser is somebody who requires someone else's consent for that agreement, you'd want to be sure that that consent was obtained?
You know, that is very difficult for me to answer this because in my case where I am sitting here, I sign just about everything and my husband signs just about everything as long as we have agreed that I will sign and he is going to sign. And he does not have to write that anywhere that he is giving me that authority.
Yes, I understand that. But I'm talking about a situation not where you are the purchasers. Here you're the seller through Slipknot, your company, correct?
It works out the same, Chair.
No, let me explain to you why I say to you it's different. You're selling this through a company, right? Slipknot,
Yes.
correct? You've got a purchaser on the other end of the transaction who's buying it herself, not through a company. That was known to you, correct?
Yes,
Right.
yes, Chair.
Now, in order for you to be sure you've got somebody on the line for this agreement on the other side, would it not concern you to establish whether she doesn't need the consent of her spouse to enter into this agreement with you?
No, Chair,
No.
it doesn't concern me at all.
And if you subsequently discovered that the law required her to have the consent of her husband and she didn't, would that concern you?
No, I don't know about that.
You don't, because then
No, but
And really, it
the
really doesn't concern me as long as we do the purchase agreement and it happens and it goes through, whether the person has got authority to sign and he can sign with the consent of the husband, how are they married, that's not for me. I always use the conveyancers to do that. So if they have done the checks that they need to do, I'm happy with it.
Well-
So if you are asking me from here, sitting here, that has it ever occurred to me that I confirm if the husband does agree with that, really, I never did that.
Well, it's one thing to say you never did that, but I'm more worried about something else that you seem to say, that you would not be concerned to find out whether the person has authority. Did I understand you correctly? I understood you to be saying, in effect, you don't care whether the person to whom you are selling the property or with whom you are entering into a contract has authority to enter into that contract. Did I understand you correctly?
My assumption, Chair, when a
No,
person-
let's start with, is my understanding of your evidence correct?
No, Chair.
Okay, what did you say?
I'm saying, Chair, if a person comes and says, I want to buy your property, I'm buying your property. For me, it never occurred to me that a person would come and say, I want to buy this property, only to find out that the person does not have authority. And
Yes.
in fact, I don't even remember a person asking me if I have authority to sign as a buyer or as a seller.
Yes, but that's where I'm concerned, because you seem to be conveying the message that to you it's not something you would bother about, whether the person who is buying your property has authority or not to enter into that contract. Am I misunderstanding what your attitude is?
You are misunderstanding me, Chair.
Okay.
Again, let us look-
Don't go on to explain, because you have explained. Let me ask another question. If you are selling property to somebody, would it be one of your issues that you would want to satisfy yourself about, that the person does have authority to enter into that sale agreement?
Not for me, Chairperson, as an individual. When I buy or sell a property, there are people involved in doing that. There is an estate agent, there is a conveyancer, and in fact, the registration process up to the deeds office would have to make sure that the person has got authority to sign. And therefore, for me, in my position, that will not concern me, because I know that the specialists in that area will be able to make sure that that happens.
Well, it's one thing to say, I would be concerned whether or not the person has authority, but I would leave it to somebody else, a conveyancer, to check whether that is done. And if the conveyancer were to go ahead without checking, I would be upset with the conveyancer. So is that your position?
Yes. Thank you, Chair.
So authority is something you would be concerned about, but you would leave it to the conveyancer to check whether that's in place.
Yes, Chair. Thank you.
Okay, all right.
And in this case, we've confirmed that the conveyancer was your lawyer today, Ms. Mbanjwa, correct?
You've confirmed that?
No, actually, that part, the conveyancer, is in the
yes,
agreement.
Our
yes.
conveyancing is
Yes.
done by her.
Yes.
Yes.
So you were, as a consequence, satisfied to entrust Ms. Mbanjwa with doing all of these checks, correct?
Yes, Chair.
Yes. So that was the first feature that I put to Ms. Mamela, and I wanted to have your side of the story because you're the other contracting party. The second feature is that...
Maybe before you go to the second feature,
Certainly,
Ms.
Chair.
Hofmeyr, Ms. Kwinana,
Chair.
I would be concerned if you would go to the extent of signing the agreement without knowing whether the person has authority. Because if you sign the contract, once you have signed the contract today, maybe, this agreement that you signed didn't even have the time within which the purchase price had to be paid, if I remember correctly. If you have signed this agreement and somebody who had heard about you selling property comes up tomorrow who wants to buy it, you wouldn't be able to sell it to that person, even if that person said, I've got cash, I don't have to apply for a bond, I've got cash right now, I like your property, I want to buy it. You wouldn't be able to sell it to that person because you now have signed an agreement with the person that you have signed with, and you don't know if they have authority. Later on, if it turns out that the person doesn't have authority, you may have lost a good opportunity to sell the property. So you don't want that to happen when you are selling property. You want to make sure that if you conclude a sale agreement with a person, at least things such as those are taken care of, because you don't want a month, 2 months down the line, 3 months down the line to find that there's a problem because this person doesn't have authority from the husband or wife. And in the meantime, you have lost buyers who didn't have any problem, who could have bought the property and the cash would have been in your bank account. So it makes sense to me that by the time you sign, you should want to have satisfied yourself, because you don't want this type of situation that I'm talking about to happen. Can you see that reasoning?
Yes, thank you, Chair.
Yes, okay, all right. Ms. Hofmeyer?
Thank you. There were also issues about whether Ms. Mamela would have had access to actually the 2.8 million required, because the previous month her bond had been declined for half of that. And then there was another feature, which is that the FICA document that Ms. Mbanjwa obtained from recording Ms. Mamela's information was only done on the records of that document the following year. Were you involved in Ms. Mamela providing the FICA documentation to Ms. Mbanjwa at all?
No, I wouldn't know that, Chair.
It wasn't something that you dealt with when you met together to conclude the agreement at all?
No, Chair.
No. Okay, and then there's another feature of this agreement that I was interested in, and that is, oh, sorry, before I go there, there are other agreements that Slipknot has entered into to sell property, is that correct?
Yes, Chair.
Yes. Does it sell property quite regularly?
No, Chair.
No. So how many times?
Maybe one property per year.
One per year, okay. Now, there was one other Slipknot property transaction that we had records of, and that is contained in your bundle. If you go to that at page, it's DD 33A at page 89. DD 33A at page 89.
I've got a bundle written on this bundle BB 33 without the A.
Oh, does it have page 89 in it, Chair? Oh, apologies, I might be adding I am, sorry. I get confused between Ms. Mieni's bundles, which are 34. No, there's only a 33. That's correct. Apologies, everyone.
Okay.
So it's just 33, and we need to pick up page 89.
Okay, no, I think it's got page 89. Yeah.
And Chair, just to check, that's a document headed sale agreement, right? And as I understand it, Ms. Mbandwa was also the conveyancer on this agreement. Is that correct?
Yes, Chair.
Yes. Now, this is a 2018 sale agreement. And what I just want to highlight to you is, certainly to me, the quite stark differences between this agreement, the sale agreement, and the one that we've been looking at, the one with Ms. Mamela. Can I just ask, did this agreement go through? In the sense that, did the property transaction take place? Nothing fell apart on this agreement?
Yes, Chair.
It went through? If
Yes,
you'll just
Chair.
say yes, thank you. Because, you see, previously you said, no, the issue of Ms. Mamela not having ready cash of 2.8 million was all right because in due course she might be able to apply for a bond and get one. Is that right?
Yes, Chair.
Yes. You see, usually when that's the case, when this purchaser's obligations under the agreement permit her to get a bond, that will generally be catered for in a suspensive condition relating to bond finance, right? Because otherwise you've got no protection. The purchaser is on the line tomorrow for the 2.8 million, unless she's allowed to take some time to get a bond. So I want to show you in your other slip knot agreement, prepared by Ms. Mbanjwa, what that would look like, and you can go to page 92 for that. You see at page 92, clause 3, it says suspensive conditions. This offer is subject to the following: that the purchaser obtains mortgage bond finance from a recognized bank or financial institution in the amount of 11,500,000. It says 200 Rand, but I don't see a 2 in the numbers. Anyway, let's call it 11.5 million. And then it always stipulates a time for the very reason that the chair has indicated to you. You're bound to this person. They are your purchaser, and you must know how long you're bound to them for, because you might get another purchaser tomorrow who can better the deal, right? So that's why that they can get financing and that there's a time limit is a key protection for the seller. Do you accept that?
Chair, these are two different properties. And as I said, this property did not have...
Hang on, Ms. Kwinana. The question is whether you accept that this way of doing things when you sell a property gives the seller protection. In other words, if the person must still go and raise a bond, you say, put that as a suspensive condition, you give the time within which they must obtain the bond. Because once they have failed to obtain the bond within that time, you are then free to look for somebody else or to sell the property to somebody else, as opposed to a situation where you simply say, this is the purchase price, and you put no suspensive condition, you put no deadline by when the price must be paid. It doesn't protect you because somebody else could be wanting to buy the property, maybe even for a higher price, and you are waiting for this person, I don't know for how long, to pay, because in the agreement you didn't even say the purchase price must be paid within a month or within 3 months. You didn't even say that. You just left everything open. Do you agree that this way of doing things is or provides protection to the seller?
Yes, Chair. This way of doing things is providing protection to the seller.
Yes.
However, that property in East London, I have stated the challenges that it had since 2007. And therefore, Chair, for me to have an agreement of sale on that property was even better than not having an agreement of sale at all. As I have been saying, I was trying to sell it to Buffalo City and so on, and all its challenges that I have stated here. And therefore, that property would not have the stringent suspensive conditions as the same as this one. This one basically was ready to go. It was occupied, it had a tenant, so everything was fine with regards to this. And therefore, we just cannot compare this property with the other one.
Would you not
However,
lose
Chair,
out, Ms. Kwinana, would you not lose out on the basis of the agreement that you had with Ms. Mamela? If somebody else, a few days or a few weeks after you signed the agreement, said, I actually want to buy the property, I'm ready with cash.
If somebody else would come, Chair, I would go to Mrs. Mamela and ask her nicely that let us get out of that agreement, as she did with me when she decided that she wants out of that. She came to me and said, this is not working and therefore I need to buy. Let's get out of that. So basically that's exactly what I would do, because she also did that.
But,
Ms. Hofmeyer?
but Ms. Kwinana, what you've described, I have to put to you, is the loosest arrangement possible. It doesn't make sense to me that you took the time to write anything down then, because what's written down is meaningless. She could have chatted to you because she wanted to get out. You could have chatted to her because you wanted to get out. Why sign the agreement then? It was worth nothing if it was actually that you could just chat to each other and get out of it at any point.
You are correct, Chair, by saying it was worth nothing, because that agreement fell through anyway, and therefore there was never a transaction that took place there.
Yes.
So maybe you are correct by saying it was the loosest agreement, because also when she cancelled the agreement, there were no penalties, because I wouldn't know what would be the penalties for in view of the challenges that I stated.
I'm going to put you in due course that it is clear that there was no need for this to be entered into, recorded in writing in April of 2015. The need arose when Ms. Mamela faced difficult questions from this commission about her receipt of 2.5 million, and this whole story had to be constructed to try and justify it. Let me put I'm going to come to that in a moment, but in fairness, I just feel I must tell you where we're going. What is a domicilium address, Ms. What's your understanding, Ms. Kwinana, of a domicilium address?
I don't know, Chair.
Because you have to fill it in when you conclude agreements. Have you previously been asked by lawyers to give them domicilium addresses?
Maybe, Chair, they would ask it differently, but I don't know what the domicilium address is.
Okay. Maybe, have you had them ask you for an address at which you can receive any documents related to the agreement?
Yes.
Yes. Okay. So you recall that. Sorry. I'm using the legal term and I actually shouldn't have. It's also Latin, so we should never deal with Latin. But it's.
But I think, I would think that Ms. Kwinana would understand. My own understanding of chartered accountants is that they help businesses, they advise businesses, they help businesses enter into business transactions, contracts, and so on. So I would expect that Ms. Kwinana, being a chartered accountant, would know what you're talking about if you talk about the domicilium address. So yeah, okay. Okay,
Excuse me, Chair.
yeah,
In fact, when we were going to start this morning, I wanted to plead with you, Chair, that whenever you wanted to talk or comment about my incompetence, you do not mention my profession. The reason being that, Chair, if the State Capture Commission has to be the graveyard of my profession, of me as a professional, don't allow it to be the graveyard of the whole profession. And therefore, Chair, I would appreciate it when you prove my incompetence. You prove my incompetence for me only as Yakhe Kwinana, not my competence as a chartered accountant or my competence as a FICA member, because the effect that it has out there, you may not know, Chair, the influence that you have in that chair. You've got a very big influence in the, maybe I would comfortably say, in the whole world. But if you, when you want to show me that I am incompetent, you say Mrs. Kwinana is a chartered accountant. Out there, you are killing the profession of chartered accountants. And therefore, Chair, I plead with you that if there is something I do not know, I will not know that because I am a chartered accountant. I will not know that because of my stupidity as an individual. I have got full confidence in South African Institute of Chartered Accountants. And if I am sitting here as a disaster to the profession, please separate me from the profession to save the profession. Thank you, Chair.
no, Ms. Kwinana, well, I'm happy that if you felt that way, you have expressed that. But the effect of the matter is that we all get judged by what we are expected to know. Okay? There are certain things that you and everyone else expects a lawyer to know, but doesn't expect somebody who is not a lawyer to know. There are certain things that you and other people expect a judge to know, but not somebody who is not a judge. So when you give evidence, and you said you are a chartered accountant, in fact, you might find that the reason why you were appointed to the board of SAA might be that it was because you are a chartered accountant. They needed the skills and knowledge of somebody who is a chartered accountant. And maybe if you were not a chartered accountant, they would not have appointed you. They appointed you because they wanted the knowledge and experience and skills that come with somebody who is a chartered accountant. And when you deliberate on matters as a board, there are certain matters where they would say, Ms. Kwinana, you will have to guide us here because you are a chartered accountant. There are matters where if the board deliberates upon, they would look for a lawyer among the board members and say, so and so, you'll have to guide us here because you are a lawyer. So, but therefore, they look at your performance as a board member, among other things, against the background of the skills and knowledge that is expected of you by virtue of your profession. You understand? If you serve in a board and you are, let's say, a school principal, they might expect certain things from you and knowledge and experience, but they might not have the same expectation. They might not expect you to guide them on law. They might not expect you to guide them on matters that a chartered accountant knows about. You understand that? So that's the context. I was saying to Ms. Hofmeyer, I'm under the impression that chartered accountants guide businesses and so on. That's my understanding, but you might say, no, that's not what I've been doing, and therefore maybe if others do that, I've not been doing that, so maybe I don't have that experience that others might have. But I'm simply saying I'm informed by my understanding of part of what chartered accountants do, what I understand them to do. So that's how it comes in. You understand now?
Thank you, Chair.
Yeah, okay, all right.
You said that you had been asked when you've entered into these transactions previously to provide an address at which you will receive notices under the agreement. Is that right?
Yes, Chair.
Yes. You see, that's quite an important thing, and I wonder if this has been explained to you. You can tell me if it has, because notices under an agreement are sometimes very important, like a breach notice, right? You let the other party know that they've done something that's in breach, and unless they remedy it, then you're able to get out of the contract. So do you accept that being able to receive the notices under an agreement is an important thing?
I really never thought that it's an important thing. Thank you for bringing that to my attention.
So you wouldn't, until this moment, have been concerned to ensure if there's an agreement you really want to be in and the other party thinks you're in breach of it, you wouldn't want to have been alerted to that fact, or do you accept you would want to know if the other party contended you were in breach so that you could adjust your conduct and then stay in the agreement?
Yes, Chair, but that would not be in the form of an address. I would think that in this case, the email would work.
You see,
Just repeat that.
Ms. Kwinana said she thought in this case, I think with a bit of a wry smile, that an email would be sufficient. But you see, Ms. Kwinana,
on a lighter note, Ms. Kwinana, you don't think that driving to where the person is to deliver it personally would be okay?
Sorry, but that is actually the point, because email is not adequate often for notices under an agreement. That's why specific addresses are given for delivery of the notice. Actually, your point highlights how important a domicilium or an address at which you'll receive notices in, because it's what creates the obligations between the parties. But Ms. Kwinana, I understand you to say that that significance of it has not previously been drawn to your attention. Is that right?
Yes, Chair.
Okay. So when you concluded this slip knot agreement with Ms. Mamela, you had to provide a domicilium address. Okay. You'll see that at page 374. Have you got it there?
In DD 33.
In DD, oh, sorry, no, we're back in DD 25, where you had the slip knot agreement a moment ago, DD 25A.
On page 375.
374 is where the domicilium address is.
it actually starts at 370.
Yes, correct, Chair. And then I'm going to the last page where the domicilium address is. So I understand your evidence to be, albeit that you might not have known it was called a domicilium address, you do have experience of being asked to provide an address at which you'll receive notices under an agreement, correct?
Yes.
Yes. So this address for the seller would have been provided by you, correct?
Yes, sir.
And you gave the address of 92 President Park, Midrand, is that correct?
Yes.
Yes. That was not an address from which Slipknot or you were operating, though, in April 2015, was it?
I would have to check when did we vacate 92 President Park?
Yeah, I can tell you when it was. It was in 2013. Does that help you with your memory?
I'm really not sure, Chair.
Well, we've obtained an affidavit from the person to whom you sold 92 President Park, and he took occupation in 2013. Do you dispute that? Do you want me to take you to his affidavit?
I may not dispute it, but it would be good if you can take me there, Chair.
Sure. Sorry, I'm running out of space, Chair. I
Okay.
just have to find the correct
That's all right.
file. Okay, it's back in your file, which is DD33, and you'll find it under tab 18. It's page 201. This is an affidavit, Chair, that the Commission obtained from a Mr. Mark David Bates. Apologies, Chair, I see you're not there yet. It's an affidavit from Mr. Mark David Bates. He is a member of a particular family trust, and what he details here is that that family trust purchased the property at 92 President's Park, Midrand, Gauteng. He indicates that it was purchased in, this is at paragraph 4, Ms. Kwinana, on page 201. He says it was purchased on auction on the 27th of November 2012 for an amount of 6.160 million. And he says that the previous owner was Slipknot Investments, that's your company. And then he says on transfer in 2013, they vacated the property and we've moved on to the said property. That's where I get that from. Does that jog your memory?
Yes, Chair.
So, Ms. Kwinana, that is the, I suspect.
It jogs your memory and you agree that you vacated the property in 2013?
Yes, Chair.
Okay.
Thank you, Chair, for the follow-up question. That, Ms. Kwinana, is the final feature that I'm going to put to you, suggests that this agreement is not a genuine one, because the domicilium address that's given is not an address at which you would ever have been able to receive notices under this agreement. You'd sold it 2 years, 3 years previously, somebody else was in the property. Do you have a response to that?
I think, Chair, it was because of my not knowing what is this word?
Domicilium.
Domicilium. Yes, Chair.
No, Ms. Kwinana. You knew that you were giving your address in the agreement, isn't it?
Yes, Chair.
You knew if this agreement was signed in 2015, this was no longer your address, so therefore you could not have given this address, 92 President Park, Midrand. Because you can't tell me you didn't know where you lived, because you certainly were not living at 92 President Park anymore.
I'm sure, Chair, that was maybe an omission on my part, because that address has been my address for the better part of my profession.
No, Ms. Kwinana, but it can't be. You can't in 2015, when you are required to put the address where you live, give an address where you lived 2 or 3 years before, because you know where you live. In 2015, you know where you live. So it can't be.
That's why I'm saying, Chair, maybe it was an omission on my part for not knowing what that meant.
No, Ms. Kwinana, please, you can't 2 years later, 2.5 years later, think that you live where you lived 2 years before and you left. It can't be. Right now, you know where you live, isn't it?
Yes, Chair.
And if you are asked to give the address of where you live, you'd give the address of where you live.
Maybe, Chair, if they said in that, instead of saying domicilium, maybe if they said, where do you live?
No, Ms. Kwinana, with all due respect, the great challenge, I put it to you with your answer, is that there's no world in which, if this agreement was genuine, and in 2015, you're asked for the address at which you're going to receive notices, you give an address that you vacated 2 years previously. I want to put it to you that this error is the type of error that creeps in when people fabricate agreements and documents. Because you have to keep so many balls in the air. You have to keep so many things, because you have to go back in time, you have to recreate facts that didn't happen, and these are the little indicators of the error. It's akin to the error in the agreement between Mr. Nzeku and allegedly Ms. Hlotlela that was allegedly concluded at the end of 2015, because it refers to a clause and a dispute resolution mechanism that didn't exist at the time. This is the equivalent in your agreement, I put it to you. Because you just don't make this error when it's happening as a fact. You make this error when you are sitting 4 years later, the commission is investigating matters, it's pursuing corruption, and then you make an error like this. What is your response to that?
Chair, your conclusion on this matter is very much incorrect. This transaction did not go through, firstly. And secondly, why would I fabricate the address if I knew how important it is, as I now know how important it is? In fact, even my postal address, I still use the postal address that I was using when I was at 92 President Park.
But that's because you have not changed the postal address, Ms. Kwinana. You have changed the residential address. That's the difference.
Chair, I no longer use that postal address, but in fact, I don't have a postal address now. But now, if they say postal address, I say PO Box 3949, Halfway House.
Let's leave out the postal address, Ms. Kwinana. Here is what has happened. On your version, you signed this agreement in 2015, April 21, with Ms. Memela, where you were supposed to give your address. You gave the address where you lived 2 or so years before, and not where you lived in April 2015. Ms. Hofmeyer says to you Ms. Kwinana, there is no way of explaining this kind of error. Because if you sign a document today and you are required to put in your address, there is no way you can forget where you live today. Okay?
Yes, Chair.
But if you do this agreement today, but wanting to put it as an agreement that was done 5 years ago, that's when you might make the mistake and think that 5 years ago you were living in this address, and it turns out you made a mistake. So if you signed this agreement in 2019, but wanted it to reflect that it had been signed in 2015, you might have thought in 2015 you were still living at 92 President Park, and that's why you put it. But you can't make that mistake if you are signing the agreement today about where you live today. You'll answer that, and then I'll go to Ms. Mbandra. But I want you to answer that first. What do you say to that? That's what Ms. Hofmeyer is putting to you, that the only explanation that can be advanced for this is that at the time you signed this agreement, it was not on the date that is given there, and it must have been much later, and you had to try and remember where you lived, and you got it wrong.
Chair, in 2013, I lived where I live now. The only thing that changed is the office.
Yes. Sorry, can I just come in there? I know
Yeah.
Ms. Mbandra wants to speak, but it is just important. You needed to give the address of Slipknot, right? The business, yes, where you were operating from. So in respect of all the chair's questions, albeit that the chair was emphasizing where you live, it's where you were conducting your business, because you, as we have it, we've gone back to Google photographs, I assure you, you were operating as Kwinana and Associates at 22 President Park for a long period, but that changed in 2013, correct?
Yes, Chair.
Yes, so the point still remains. It's just that it's the business address, yes. Thank you. Apologies.
1 second, Ms. Mbandra.
Thank you, Chair. It has been answered.
It's been answered.
To point out that it was
The business, yeah.
and not-
Okay. The principle is the same. It's just that it's the business, but the principle is the same. You understand the principle?
Yes, Chair.
Yes. Are you able to offer any explanation as to how, if this agreement was signed in 2015, you could have given an address for the business where the business was not operating from?
As I said, Chair, I'm sure it was a omission or ignorance or not knowing what domicilium means.
Ms. Hofmeyer?
Thank you. I'd like to then move to what I hope will be the last major topic, and then there'll just be a few little points. This is about your role in SAA and the auditors that were appointed. You anticipated earlier that you thought that I would likely go there, and so I am going there. Ms. Kwinana, you were involved in the decision taken back in 2011 to go out on tender for the auditors for SAA. Do you remember that?
Yes, Chair.
And that was a tender for auditors to be appointed for the financial year 2011-2012. Do you recall that?
No. I have seen the hearings of the auditors, and I am almost sure that there is no way that for such a big entity, in fact, even if it is a small entity, there is no way that we would appoint an auditor for 1 year. The reason being that, you see, SAA on its own is complicated. Even if you audit for 5 years, there are still new things that you are learning. And therefore, that is why most of the times, auditors are appointed for a period, a minimum period of 3 years. So I was surprised to find out that the contract basically is saying 1 year. It also boils back to what I have been saying about the contract, that the board would decide here, and then the contract is drawn elsewhere. And in fact, the reason why I remember very well that it was not 1 year is because we deliberated a lot on transfer of skill and how the auditors should share the work going forward. And in fact, we did say in that meeting of the deliberations with the auditors, we did say that first year, the job should be shared on 50-50 basis. And then second year on a sliding scale until in the end, Gongi gets 100%. That's basically what we said. And therefore, the 1 year, how did the auditors get the contract of 1 year? It is just not possible. Especially, it's not possible with most of the companies. We know that the auditors do get annual renewal subject to their performance, annual renewal at the annual general meeting. But for SAA to issue out a tender of 1 year was a big mistake, but I don't think that is what the board decided, because it is not practical. Can you imagine the auditors auditing SAA for 1 year, and then the following year, and then there needs to be another tender process which takes about 6 months, and then the other new auditors come and learn the business. The previous auditors have not even learned the business. So I think that was a big mistake.
You said two things. You said it was a big mistake and you said it didn't happen. Which is it? It could have happened and you could now review it and say it was a big mistake, or I also understood you to say it didn't happen. What is your evidence?
I will not say it did not happen for the reason that I did not see the contract. So if you have the contract that says 1 year, then that means it did happen. But definitely that contract did not reflect the discussions of the board.
I see. So you say the contract differed then from what the board had concluded. Is that right?
I think so.
Okay. You were on the audit committee at that time, 2011. Is that right?
Yes, sure.
And you became the chair. I just want to check this. When was that? That was sort of December 2012. Is that right? I have it here. Let me just look at my notes. Well, can you help me? When did you become the chair? It was November 2012, correct?
I don't know, Chair. If the company secretary says so, that's fine.
Those are our records.
That's fine.
Okay. So you're a member in 2011 and you become chair, let's say, in November 2012. Do you accept that?
That's fine, Chair.
Okay. You see, Ms. Kwinana, the challenge is that as a member of the audit committee, you recommended to the board that SAA go out on tender for 1 year?
No.
Yeah, let me take you to the minutes. You will find them in DD 19A.
What page?
We are going to, the minutes start, sorry, let me get at page 54, 54. Yes. Now, these are minutes of the meeting of the Board of Directors of South African Airways held on the 17th of February 2011. And it is who is present there is listed, and I see your name there. Do you confirm that?
Yes, Chair.
Yes. So this indicates you were present at the meeting, and if you go over to page 55,
let me read the people who are here.
sorry, I'll tell you where you are. You're just under Ms. Nkosi Thomas, the 1, 2, 3, 4, 5, 6, 7, 9th person. Do you see that?
Yes, Chair.
And then if you go over the page to page 55, you go down to clause paragraph 10.2, which says audit committee. Do you have that?
Yes, Chair.
There's a report and recommendation, and then at 10.2.1.1, there's a bold open tender process for the appointment of external auditors for the 2011-2012 financial year. The Board of Directors reviewed the proposal to commence with an open tender process to appoint external auditors for the 2011-2012 financial year as recommended by the Audit Committee and tabled at the meeting. How in the face of this, Ms. Kwinana, can you say that it was not, in fact, the recommendation of the committee on which you served that the very thing that happened happened?
I think this was a very big mistake, Chair.
What was a big mistake?
A mistake that the board reviewed the proposal to commence with an open tender process to appoint external auditors for 2011-12 financial year, recommended by the audit committee and tabled at the meeting.
What was the mistake? Are you saying
to
that?
recommend for 1 year, maybe, Chair.
But
Do you
you
have the
accept,
minutes?
okay, Ms. Hofmeier's question, as I see, seeks to establish from you whether you accept that it's the Audit and Risk Committee that made that recommendation. Do you accept that now?
Do you have the audit committee minutes where this was discussed?
Ms. Kwinana, no, we don't have every single recording of every single meeting, which when I show you the record of the minutes, you try to rely on to give more than is recorded here. Ms. Kwinana, how in the face of what's recorded here, can you not just resolutely accept the committee of which you were a member recommended that the tender go out for only 1 year?
Definitely, Chair. There is just no way that we can recommend 1 year. In this meeting, Mr. Zakhele Stole was the chairperson of the audit, and Mr. Zakhele Stole was operating an audit firm. And also, there is just no way that we can recommend 1 year. Never, Chair.
But
The audit, never, Chair.
But would you not have seen these minutes at some stage during that time? Because then if you saw the minutes, you should have said, this is not correct. This committee did not make such a recommendation or could not have made such a recommendation. The
Chair,
minutes must reflect something different.
That's why, Chair, I need these minutes of this audit committee where we recommended 1 year, because I am sure that we can't recommend 1 year
But-
with audit.
But Ms. Kwinana, no, I mean, even before we get to minutes, you were present at this meeting. If you're present at the meeting and a non-executive, you say, that wasn't the recommendation. There's some
Yes.
errors happened. You don't even do that. These are signed minutes of the board of SAA. In the face of that, Ms. Kwinana, it's difficult I'm putting to you, it's difficult to understand the basis on which you resist. That the recommendation came from the committee and that the board of which you were a member approved the recommendation.
The reason, Chair, why I am resisting is because I am sure that there is no way that we can recommend for such an entity as big and complicated as South African Airways, and then we approve the audit for 1 year. Definitely, Chair.
Mr. Banjo?
Thank you, Chair. Chair, unfortunately, this is again an objection. The way I understand it, this is a commission of inquiry. And I believe what the commission wants is to be assisted with the truth. I know that Ms. Hofmeyer is cross-examining, and we are not objecting to that because we are in agreement with the chair that although that is going beyond the normal part, the truth must be established and there is no time. But where we are objecting is when a witness says, yes, I admit that this is what is written here, but this is so improbable given the circumstances and what I know of where I was working. Can I have supporting documents? And then Ms. Hofmeyer now gives this huge outcry because in a way it is intimidating to the witness chair and it forces the witness not to look for supporting documents. I think in any situation when you present evidence, you are allowed to get supporting documents.
Well, you see, the difficulty, Mr. Banjo, is that the commission can't be going and looking for every piece of document. As I understand the position, the legal team made sure that you and Ms. Kwinana were notified what documents would be used during her evidence. And you were given whatever information you would need in order to access the information. So, which suggests to me that if Ms. Kwinana had taken the trouble to read the documents, she would have come across these minutes and she would have picked up that there was something that she thought they incorrectly reflected and would have mentioned much earlier to say, those minutes are wrong. I want to try and get more documents. Yes, what do you say?
Thank you, Chair. I'm going to say two last things. It doesn't matter what Chair's answer is. If you recall, Chair, here, there is even a letter which I wrote, and I used the word irritated. And it's because from the very beginning, once we were given the date of Mrs. Kwinana's appearance here, we requested the evidence band or to be pointed out. And there was such a tremendous delay. The letter was read here. And I got frustrated because we were actually given these documents, I think on a Thursday, and we were coming here on a Monday. The whole weekend we worked on these documents. That is the first thing, Chair. And then the second thing, Chair, which I want to say is this. If a witness is saying, this is the other extra evidence, my understanding is that that evidence is supposed to be admissible. And I'm saying that because that is exactly what Ms. Hofmeyer has just done here before we went for lunch break. She had an email, and we did not object to the admission of that email because we understand that the commission is dealing with a huge volumes of information. All we asked was just for time to say, let's get 5 minutes to read the document. So we are trying to cooperate with the commission to the best of our ability. And we are happy in the manner the chair is treating us. But we have to take a strong exception to the fact that every time the witness says, maybe if I can get this document, that is immediately interpreted by the evidence leader as being evasive or refusal. What the evidence leader could correctly say is to say, yes, there are constraints, but not to shout at the witness. Thank you, Chair.
Ms. Hofmeyer?
Just for the record, Chair, the request to be provided with the bundle for Ms. Kwinana's evidence came in a letter dated the 16th of October 2020 from Ms. Mbanjwa's firm, and the last paragraph, it's unnumbered there, read as follows. In conclusion, please advise us as to when we can expect the witness bundle, including the documents specifically requested in our letter incorrectly dated. Sorry, that's the later one. Let me just get here. Sorry. So this is the 23rd of October letter. It says, remember I told you there was a whole list of requested documents, and then that was provided in addition to the bundle. What happens after the request is made is this following appears. In conclusion, please advise us as to when we can expect the witness bundle, including the documents specifically requested in our letter incorrectly dated 16 September 2020. Please note that we need an answer on or before the 28th of October 2020. So this was written on the 23rd, and they required an answer about the witness bundle by the 28th of October 2020. On the 28th of October 2020 is when Ms. Kwinana, through Ms. Mbanjwa, was provided with the witness bundle. So it was in compliance with the very date that had been set in the letter of the 23rd of October. So I just wanted to place that on record. Insofar as further documents are concerned, the challenge is the challenge is simply that in the face of signed minutes of a meeting at which Ms. Kwinana was present, and in respect of which there was a recommendation from a committee on which she sat, I'm putting to Ms. Kwinana that it's difficult to understand how going to look for the minutes of the underlying Audit and Risk Committee meeting would help. Because as the chair was ventilating earlier, if you had any concern about what is recorded here, that is likely to have been reflected in the minutes. How do you think getting those minutes will assist us, Ms. Kwinana?
Maybe before you respond, Ms. Kwinana, let me also say it just seems quite improbable that the recommendation from the Audit and Risk Committee would have been recommending a longer period than 1 year. And when the minutes said 1 year, not a single one of the members of the board who would have seen what the recommendation of the committee recommended, maybe 3 years, that not a single one of them, including you, didn't pick up to say no, but the recommendation didn't say 1 year. So these minutes don't reflect the true position as to what the recommendation said. So you can comment on what Ms. Hofmeyer said, but comment on what I've also said.
Thank you, Chair. I would say, Chair, these minutes do not reflect the discussions of the day in respect of that 1 year audit. In fact, Chair, the procurement process would take a minimum of 6 months. And then now, after 6 months, we appoint, and then we appoint the auditors for 1 year. That would mean that even before they finish that year, we would have to start another process. So that's why, Chair, I am almost sure that there is no way that we could, as a big entity and complicated and complex like SAA, we would appoint auditors for 1 year.
How long, in your understanding, were they appointed for?
For 5 years, Chair.
For 5 years?
Yes.
So your understanding, despite what's recorded in the minutes of the meeting, is that in 2011 a decision was taken to appoint them for 5 years. Is that correct?
That's correct, Chair. And in fact, the reason, as I said, Chair, in fact, the reason why I'm saying 5 years with confidence is the discussions that we went through, where basically we were saying First year, 50%, 50-50, second year, 60-40, and so on and so on. That period would be 5 years. And then we even said, then if that is, it happens like that, then when the tender comes again, now Nkonki would be in a position to tender alone without being paid with PwC, because the skills would have been transferred over these 5 years.
So your understanding is that there was a decision to appoint PwC and Nkonki for 5 years, is that right?
That's correct, Chair.
Then why did you try and take it away from PwC before the 5 years was up?
We did not try to take it away, Chair, from PwC, but this is what happened. First year, 50-50, second year, 40-30, 40-60, and then third year, that would be 70-30. And then I think in the third or fourth year, when now PwC percentage was reducing, PwC got uncomfortable with that. And they said for the percentage and the risk they are carrying, the risk is higher than the reward, something like that. And then, so that was not, we did not want to remove PwC, but PwC said, if that is the case, then we are going. So basically, we did not remove them.
Ms. Kwinana, do you not remember being very vocal about the fact that Nkonki should get it all on its own before the 5 years was up?
That recommendation, Chair, I think we even wrote that recommendation, but I'm subject to correction we wrote to the Auditor General, because the Auditor General has got the first right of refusal in terms of auditing the SOCs. So the reason why we wrote, why you may say we were pushing, but PwC said they are withdrawing. So now if PwC is saying they are withdrawing before the end of the 5 years, which means therefore that it might as well be 100% and zero. That was the reason.
No, Ms. Kwinana, that's not how the chronology actually played out. You see, PwC wasn't satisfied with going less than 50-50 at a point, but the board actually resolved to give this exclusively to Nkonki before the 5 years was up. It did so. It went to the Auditor General about that, and do you remember what the Auditor General said in response?
No, Chair, what did they say?
They said that you can't do so without ensuring that you go through a proper supply chain management process. Does that refresh your memory?
The supply chain management process, Chair, was entered into when we appointed them in 2011, and our understanding was that that is going to be 5 years, and the percentage will be on a reducing scale. And therefore, if PwC does not want that, therefore, the other company can continue. That was basically what our thinking was.
Well, Ms. Kwinana, again, I just have to put it to you. What the minutes of the meetings and the resolution show is that over time, in the 5 years, on your version, they were jointly appointed for 5 years. But somewhere in the middle, the board decides to just take it away from PwC and give it to Nkonki. They go to the Auditor General. The Auditor General says, you can't do that. You have to go through a supply chain management process because you're procuring services and you can't just give it to a party. And the board minutes reflect the following. I'll take you there in a moment. it was observed that the request by the Auditor General, that's the request to go on a supply chain management process, was, quote, strange and outside the scope of the Public Audit Act.
Where are the minutes, Chair?
Let me show you. It's in the bundle, I think, that you have in front of you, DD 19. Now, it's going to be one of the difficult ones to find because there are lots of sub-numbers, but if we could look for 132.16.3.1. A, thank you, Ms. Mbanjwa. 132.16.3.1. Chair, can I just say the only reason I haven't ensured that this gets scrapped is because I can't change the numbering now because the record is going to previously have referred to it. So I just do apologize.
No, that's fine. That's fine. I wanted to be the first one to find it because I have a suspicion I'm the oldest of all of you in this room. And it's good to find it first.
First, indeed.
Yes, okay.
Okay, so these are the minutes of the special meeting of the SAA SOC Limited Board of Directors held on the 28th of September. Oh, sorry, Ms. Mbanjwa. Point 3.1. Sorry, please let me know when you have it. Yeah, yes, that's where they start. Do you have that, Ms. Mbanjwa? It's the minutes, right, of the, this was a very significant meeting. You'll recall it's the one that I started with on Monday. It's the one where the LSG Sky Chefs contract is taken away and given to Air Chefs. It's the one where the CEO's delegation of authority is cut from 100 million to 50 million. And then the other thing that happens at this meeting is in relation to auditors. And you'll find that at internal page 15 of 17, which is the bundle page DD 19A, page 132.16.3.15.
Page 15 of 17.
Correct, internal page, yeah. And you'll see against paragraph 13 there, appointment of auditors. It was reported that the board had approved the appointment of Nkonki as the sole auditor for the SAA group. That happened previously, but this is where we land in September. The Auditor General had written to SAA requesting proof that there was compliance with the supply chain management policy before the AG was willing to consent to the appointment of Nkonki Inc. And then there's this recorded, it was reserved that the request by the Auditor General was strange and outside the scope of the Public Audit Act. So this is the basis, Ms. Kwinana, on which I say to you, even if, notwithstanding what the minutes of the 2011 meeting record, your version is that there was an appointment for 5 years.
Yes, Chair.
The difficulty that this presents is that at a point within that 5-year period, the board of SAA decided to take it away from one of the joint audit partners, give it to Nkonki, and it was the Auditor General that wouldn't approve that unless there was proof that there had been compliance with supply chain management. So how, on even your own recollection of what was decided, could this have been an appropriate thing to do?
I have tried to explain and give the background to this, Chair. And in fact, I don't know, maybe if I had explained it in Xhosa, it would be better. But as I said, Chair, the auditors, according to the board, were appointed for 5 years on a sliding scale. And therefore, when PwC refused to take a smaller percentage, then they decided that they are withdrawing. And then now, when they are withdrawing, then the board, as it is stated here, approved the appointment of Ngongi only because PwC wanted out of the deal. And when the Auditor General says they wanted proof of compliance with supply chain management policy, the Auditor General didn't know what was decided in previous years. And therefore, and I also do not think that it would be difficult for SAA to be given the assurance that there was compliance. But assuming that they would have been given the 5 years that the board discussed in the meeting. So we really did think that the Auditor General's request was in fact strange, because our understanding has been that the auditors were appointed on a sliding scale anyway. So in one way or another, maybe in the 5 years, it would end up being 2080. And maybe if there is an extension, as it happens with other contracts, it would end up being 1090. So, Chair, I do not have any other response except that I have explained what was the discussion in respect of this.
Ms. Kwinana, during the period that PwC and Konki were jointly auditing SAA, you entered into a joint business relationship with PwC, correct?
Not only with PwC, as I have been saying in all the meetings of SAA, there is not a single person at SAA who did not know that I operated an audit firm. And therefore, as I have been saying, you know, Ms. Hofmeyer, maybe you were never involved in tendering the way I have been involved in tendering. In tendering, in the government tender bulletin and in e-tenders, there will be the whole lot of tenders. And then if it's tendering for audit and maybe accounting or making sure that there is clean audit, you do the reconciliations, this and that. You enter into joint partnerships. In fact, maybe definitely your investigating team, when they were reviewing our bank statements as Kwinana and Associates, they would have seen that we receive money from almost all the audit firms. We have received money from PwC, from Deloitte, from not Ernst & Young, it's only Ernst & Young that we never worked with, from SNG, from Gubane, from Manasseh, from basically all the audit firms. And in fact, how we do things, we enter into different forms of arrangements. We enter into consortium arrangements where the two parties come together and form a consortium. Sometimes we enter into joint venture agreements where basically we would register the joint ventures. Sometimes we enter into a subcontracting arrangement where basically one company, as it has happened with PRASA, with Kwinana and Associates and PwC. So basically, it depends on the form of an arrangement. Sometimes you enter into a supplier development arrangement, as my understanding is that you lift as you rise. So basically, that is what we do, Chair, as the auditors. And therefore, when you ask that I entered into a business arrangement with PwC, Kwinana and Associates has entered into business arrangements with almost all the audit firms. If you go to Ngubane and ask who
Yes, don't
Kwinana
repeat
is,
that, Ms.
they will know.
Kwinana.
Thank you, Chair.
You have mentioned the various names. Ms. Hofmeyer.
The point of the question is to establish that the very joint audit partner who was auditing SAA, you were in a joint business relationship with. It's not relevant that you were in others. The one that we're focused on now is the one in respect of which you were year on year making decisions to reappoint them and determining their fees. So I just want to explain why the fact that you might have had other relationships with other audit firms is not the focus for us. Because as a board member in SAA with decision-making power, generally, and in terms of that section of the Companies Act we looked at previously, you should not be making any decisions in respect of which you have a personal financial interest. Do you accept that?
No, Chair. In respect of the auditors, I definitely do not agree with that. The reason being that, Chair, the personal interest that Ms. Hofmeyer is talking about, of course, Kwinana and Associates did receive a benefit, but not from PwC. Remember that we were appointed by BRASA, not PwC. So whenever these consortiums happen, Chair, the client would want to deal with one company and the other companies, like for instance at Transnet was dealing with 10 companies, but now there would be one company that does like the invoicing. And therefore, the benefit, Chair, in fact, I really do not know how to explain this. The benefit, the monies that PwC paid to Kwinana and Associates, and the monies that Ngongi paid to Kwinana and Associates were not the monies that PwC gave to me. They were just the conduit.
Hang on, Ms. Kwinana. I hope I'm wrong in thinking what I think you are saying. You are not saying, are you, that there was nothing wrong with you sitting, whether it's at the board of SAA or the Audit and Risk Committee, and participating in decisions to give work, SA work, to Konke and Pricewaterhouse in circumstances where your company was going to be getting, Kwinana Associates was going to be getting a benefit, financial benefit coming from the work that Konke or Pricewaterhouse or both were going to be doing for SAA. That's not what you're saying.
No, Chair.
What are you saying?
That's not what I'm saying. I'm saying, Chair.
Or let me go back to Ms. Hofmeyer's question. Ms. Hofmeyer's question, do you want to repeat your question so that I can understand what the answer is? Yeah.
The issue is that you're in a decision-making role within SAA. You're deciding year on year to reappoint or not PwC and Konke. You're deciding what fees they will earn. And at the same time that you're doing that, you're in a joint business relationship with them, and you are deriving revenue from that business relationship. That creates a situation I want to put to you in which you should not be making those decisions. The Companies Act requires you to declare the interest and requires you to recuse yourself from that decision making.
Yes, now I think I understand. So, yes, the money that would have been paid to Kwinana and Associates might not necessarily be for work done by PricewaterhouseCoopers at SAA. But I think the point being made is these are your business associates from which you derive some benefit, even if that benefit is not connected with work at SAA. But you have a too close a relationship with them to be sitting and participating in decisions whether they should get contracts or not. That's the point. Are you saying there's nothing wrong with that?
I still think, Chair, there's nothing wrong with that. And in fact, if anyone thinks there is nothing wrong with that, in my example, when I was answering by email, I said, Chair, for the auditors, that would be very difficult. That would mean that any chartered accountant, not even a chartered accountant that is an auditor, a chartered accountant that is a CFO there, cannot make a decision on any firm. The reason, Chair, why I am saying that is because a chartered accountant will have served articles in one of the audit firms. And when you have served articles in one of the audit firms, and then now...
Well, don't make that example, Ms. Kwinana, because the mere fact that he or she may have served articles at some stage or another is neither here and there. It happens with lawyers, you know. The fact that you served articles with law firm A 20 years ago doesn't mean that you can't act against them. But if you served articles and left yesterday or last month, and now you have to sit and make a decision in a structure where they are involved, that might be different. But if you are talking about a certain period, a long period, that might not mean anything. So, but here, as I understand the position, it was a business association that Kwinana and Associates had, which was ongoing. Ms. Hoffman, am I right?
Indeed, it's
Yes.
about the two happening at the same time. That's what
Yes.
creates the conflict. It's that at the very same time that you're making the decision,
Yes.
you derive benefits from your association with them, and that is what creates the conflict. It doesn't mean you can't be appointed. It doesn't mean you can't serve and give your skills and your expertise to SAA. It means on that decision, in respect of which you have a relationship, in which you derive personal benefit as defined, you just recuse yourself. You say, I can't participate in this decision.
Chair, I still do not see it like that. The reason why I do not see it like that is, as I said, I work with all the audit firms. For me, all the audit firms are the same. Even, for instance, if...
But you didn't have a current ongoing business relationship with all of them at a particular time.
Yes,
You may
Chair.
have had in the past with that one or that one, but at the time you make it, you have to participate in decision-making that could benefit these business associates of yours. You have that business association, a relationship from which you continue to get financial benefit. How can you take part in that decision-making? Not talking about some previous or past business relationship, talking about a current business relationship from which you get financial benefit.
Chair, in that case, that would mean that everybody who is operating an audit firm cannot sit in the board. The reason why I am saying that is because I did not have the business relationship at that point in time with, say, Deloitte. However, at some stage, I would have a business relationship with Deloitte because we
Yeah,
could
but we're
tender
talking
together.
about a relationship that is current at the time you are supposed to make a decision. Don't make examples that don't apply. We're talking about a situation where you participate or a decision has to be taken and you must decide whether you recuse yourself or you are going to participate, where an affected party who could benefit from the decision, from the way you vote, is a current business associate of yours, and from that business, that relationship, you continue to have financial benefits. We're not talking about something that has happened and ended. We're not talking about something that could happen in the future. We're talking about something that is ongoing at the time you have to decide whether to recuse yourself or to take part in the decision that could benefit or not benefit that party.
Let me make my final answer, Chair. I did not get a financial benefit from Kongi and PwC. I got the financial benefit, my company got the financial benefit from PRASA, Transnet, and Post Office.
Ms. Kwinana, I should just follow up on that. Is it really your evidence before this commission that your association with PwC was not part of the reason why you got the PRASA work? You jointly bid for it.
We have been, Chair, we have been bidding with PwC and other companies.
Well, just the question is not whether you had been bidding with them. The question is whether you are saying that you were not benefiting from that relationship.
Chair, even if we did not bid with PwC, we decided to bid with another company. But the fact of the matter is that the benefit did not come from PwC. The benefit came from PRASA. And in fact, when you bid, you don't know if you are going to get the tender or not. And therefore, I would not take, in fact, Chair, my conflict of interest. I did not have any conflict of interest at all, according to my understanding. And in fact, as you are asking these questions, I still do not see any conflict of interest because we would lose that tender to the PRASA tender, and we would get another tender, or we would go with Deloitte and PwC or KPMG with another one. So, Chair, I really do not see any conflict in this one.
Ms. Kwinana, it's clear you see absolutely no conflict. I'm going
Not
to leave
at
the
all.
point.
Not
Do you
at
know that
all.
Mr. Motibe, the lead PwC auditor, who in your evidence earlier this week you said you had a high respect for, believed that it was a conflict of interest for you and that you should have recused yourself from those meetings and decision-making?
That is his own opinion.
It is, indeed.
It's his own opinion.
You see, Ms. Kwinana, we might all at one stage or another not see a certain matter in a certain way. But when there has been the benefit of discussion and questions being asked, we might then begin to see that matter in a different light
Yes, Chair.
and say, you know what, that's not how I saw it at that time. But now that you are raising these issues, I can see it, you know, it was wrong. I should have seen it that way, but at that time I didn't see it that way. I'm terribly sorry because I really didn't see it that way. Now, if one is dealing with that situation, one can lay blame, maybe not lay blame, for the fact that a person didn't see a certain matter in a certain way at a certain time. But one might well be able to forgive the person to say, once this was raised, he or she saw it and she realized that, no, I'd made a mistake, you know. But even when there's discussions, there are questions, issues are raised, somebody still doesn't see it, it becomes even a bigger problem. Because if between these two people, the one who sees the problem that he or she didn't see before in regard to a certain matter, the one who sees the problem, you can, if he or she says, look, I'm now enlightened, I can see this, I will make sure I don't do it. You can work with that person because that person has seen the light. But if the person persists and says, I don't see it, I mean, the other one, you can say that person can be considered to be a board member, to be a member of another board, because at least he or she realized that, no, that was wrong, and now that kind of mistake won't happen again. But with the person who still doesn't see it, it's too risky to appoint that person in the future to a board or such a position, because this person will continue not to see that this kind of situation is problematic and therefore will cause more problems. So I just want, I'm making this example to say to you, I'm quite concerned about the fact that your position still stands, that you don't see any problem with that situation. Ms. Hofmeyer?
Thank you. The total amount that Kwinana and Associates billed PwC for on that PRASA matter was in the order of 6.1 million. Do you confirm that?
Yes, Chair.
And in respect of that 6.1 million, you were only able to enter into that relationship with PwC according to its policies if that amount didn't constitute more than 5 or 10% of your Kwinana and Associates revenue. Were you aware of that at the time?
Remember that, Chair, in a partnership, they will come with their policies.
Yes.
We will also be having our own policies. And therefore, that doesn't mean that in a partnership you have to take all the policies of the other partner that is coming. You need to sit down and discuss and see which policies are applicable, not applicable, which policies are acceptable for both parties.
1 second, I've run out of water here. Ms. Kwinana, do you still have water there?
Yes, Chair.
Oh, okay, all right. I've asked for somebody to give me water. Okay.
Would you like to take a moment, Chair, or are you coming?
No.
5 minutes break,
No,
Chair.
I don't know, is Ms. Hofmeyer, are you still, I just wanted an indication, Chair.
Oh.
I thought that we would be out in 45 minutes, so I want to know now, Are we going on through?
How
to-
far we are from finishing?
Please.
I'm on my last topic. It has just taken a bit longer, and with all due respect to you, Ms. Kwinana, I understand that you wanting to give explanations, but I can't anticipate how long they're going to be, so apologies for that. It's this one, and then it's 2 questions. So I think about maybe 20 more minutes, 15 even, possibly.
Okay, is that fine, Ms. Mbantu?
Yes, Chair, let me just say, Chair, it's not that I have time constraints. I just wanted to run to the bathroom.
Oh,
if we are
okay.
still going on.
Maybe, I think Ms. Kwinana wants to,
5 minutes break, please, Chair.
yeah, okay, all right. Let's make it 10.
Yes, indeed,
Yeah.
Chair, because it's a bit of a way to
Yeah,
go.
yeah.
I'm
So-
going to take advantage.
So we will resume at 4:10.
Thank you, Chair.
We adjourn.
All rise.
Yes.
You see, Ms. Kwinana, that may happen in certain relationships with different parties. PwC's evidence before this commission, corroborated by their policy with which they provided to the commission, said they couldn't have entered into this PRASA joint business relationship with you if the revenue to be derived from it was anything more than 10% of Kwinana and Associates revenue. So can we just work with those facts? Because those are the facts that they have presented to the commission. Okay, there might be other situations where arrangements are made, but PwC said that they won't. And they actually, for that reason, communicated with Kwinana and Associates before you entered into the relationship to ask precisely how much of Kwinana and Associates revenue this was going to comprise. Are you aware of that communication?
Let me give you a background information.
Well, could we
Hang
just
on.
start
The question
with...
is, are you aware of that communication?
I am aware of the communication, Chair,
Okay, all right.
but I want to explain, Chair.
Well,
The verification or was a subsidiary of PwC. So now, I definitely was not aware of the combined systems policy.
okay, Ms. Hoffman.
Okay, so the communication that PwC sent to Kwinana and Associates, you'll find in DD 19 at page 132.
Page 132.
Yes.
That's 19A, yeah?
19A at page, we're starting at page 132 because it's an email chain again, so we have to start at the end. Thank you.
So it's 132 what?
Just 132.
Oh,
For
that's
once,
the
we
beginning.
just have a point number.
Okay.
Do you have that, Ms. Kwinana?
Yes, Chair.
Yes, I've got it true.
Thank you. So this is a question sent, you see from just above midway down from Nikki Wayne of PwC to various people. And it says, oh, so sorry, this is internal to PwC, the one at the bottom, right? It says, hi, Koos has asked the following, please can you help with the reply to him, colon. It says, hi, Nikki, please confirm the following with your contact at Kwinana. As per the DD submitted, Yakhe Kwinana has no other shareholdings or directorships. However, as per the SIPC info, she's a director at South African Airways or SAA Technical, a PwC audit client. Please see if she is still a director there. Please determine if the JBR, that stands for Joint Business Relationship on the evidence of Mr. Motibe, with PwC will be material for Kwinana. In brackets, if the fees for Kwinana for the current JBR relationship or engagement with PwC exceeds 10% of their annual turnover, the relationship will be deemed material for them. Close quotations. Okay. Now that is then sent by Nishan Pershad, you're now at the top of the page on the 9th of December 2014, to Lumka Goniwe, that's your daughter who works at Zanospark with you, is that right?
Yes, Chair.
It's entitled Department of Education Internal Audit Kwinana JBR Query. And it says, good morning, Lumka. I trust all is well. As discussed, please find the queries from our risk management section. So that's the query you saw previously, and it's being forwarded to your daughter. And then what your daughter responds with, and now you have to go back to page 131, in an email halfway down, Chair and Ms. Kwinana, dated the 9th of December 2014, to Mr. Pershad, is, good morning, Nishan. We've calculated our fees to be in the region of 6.1 million excluding VAT. I confirm that Kwinana and Associates turnover is more than 50 million, and then they go on to deal with.
I'm sorry, you said 6.1 million?
Did I say 6? I apologize.
Yes.
They ended up receiving 6.1. I made the error. I apologize.
Oh, okay.
So this is your daughter just calculating an estimate, as I understand it. We've calculated our fees to be in the region of 4.1 million, excluding VAT. I confirm that Kwinana and Associates turnover is more than 50 million. And then she deals with BE certificates and confirms that you are a non-executive director of SAA. Were you involved in assisting your daughter with this email response at the time?
No, Chair.
No, because we went to go and check the tax returns of Kwinana and Associates, which puts the turnover at a much lower figure than that. Are you aware of that?
I'm not aware, Chair.
You see, it puts the Kwinana and Associates tax returns said that the turnover was 10.5 million for the year ending February 2015. So when your daughter sent this email and was alerted to the fact that the PwC requirement was that it mustn't be more than 10%, she stated here that the turnover is something that's very different to the turnover that appears in Kwinana and Associates tax returns. Why would she have made, and it's an error of considerable magnitude, because it's 5 times. She says the turnover is 5 times more than what appears in the tax returns. How could she have made such a glaring error?
I don't know, Chair.
You see, because of that false representation of the turnover, it fell within the policy, and so the arrangement could continue. If she'd gone back and given the tax return information that Kwinana and Associates represented to SARS, then you wouldn't have been able to enter into the relationship. You accept that, because 4.1 of 10 is much more than 10%. You accept that?
No, Chair, I don't accept it. As I have stated the reason, it depends on a relationship that you want. There is a compromise in any relationship, and therefore, if they wanted to tender with us, as I said, even if we had 0 turnover, and in fact...
Yes, but I think Ms. Hofmeyer is asking this question on the basis of the correspondence from them, to say they had a policy that went this way. If you fell outside of the turnover of Kwinana Associates, fell outside of that bracket that they're talking about, then in terms of that policy, Kwinana would not be able to enter into an arrangement with them. Whether in terms of some discussion that could follow, that they might not enforce that, I don't know. But in terms of that policy, do not accept that Kwinana would not have qualified to continue with them.
Chair, these relationships, it's not a matter of qualification or qualifying or not.
Just raise your voice, please.
Sorry, Chair. This relationship, it's not a matter of qualifying or not. The 10% threshold may be, in fact, their guideline. But I don't want to say if there was no overstatement of revenue or understatement of revenue, we would not have entered into this relationship.
Okay.
No, I accept that, Ms. Kwinana. Do you accept that your daughter misrepresented to PwC by 5 times the relevant annual turnover for that year?
I can't confirm that.
You can't.
No.
So if I show you the tax return, will you be able to?
I will still not be able to confirm it.
So you can't confirm. If I show you the tax return, it shows 10 million. And I've shown you an email in which your daughter communicated 50 million. You will not confirm that she misrepresented the position 5 times to PwC.
I will not confirm, Chair.
Why would you not be able to say that? You would have
I
all the
would have,
facts in
I
front
would
of you.
have to conduct my own independent audit and then come back to the commission and confirm. But as I am sitting here, I'm not going to confirm that, Chair.
But the information reflected in the text documents would it not be the correct information?
I would have to conduct my own investigation, Chair.
That might not be necessarily the correct information, the one in the text documents.
Chair, I may have to conduct my own investigation.
Yes, but I'm asking. The text information that you have put into the, you have given to SARS, would it not be the correct information?
I would have to recheck it, Chair, because also, even with SARS, for instance, you may put some incorrect information, you may have omitted something, and therefore that's why I am saying I am not going to confirm, Chair.
Let's leave out the 5 times.
Sure.
Would you not concede that what your daughter, the information she gave, was not correct
Chair,
in terms of the turnover of Kwinana Associates at that time?
Chair, before I say the information that she submitted is correct or incorrect, I would have to be given an opportunity to go and audit. I don't want to say it is correct or incorrect. I'm saying I need to go and audit before I can answer this question.
So to the extent that she said 50 million, that doesn't sound to you like that can't be true.
Chair, I need an opportunity to go and do my own verification.
Mr. Mayor?
So you didn't make sure when the tax return was submitted at the time that the requisite checking had been done?
Chair, I am going to go and do my own verification.
Ms. Kwinana, that wasn't my question. My question was, at the time that Kwinana and Associates told the South African Revenue Service that its annual turnover for that year was 10,567,581 rand, did you not check that before you submitted the tax return?
Chair, I do not submit the tax returns for myself. I don't do the tax returns for myself. I do check the tax returns. However, I am saying I need to go and audit and confirm if the figure that is stated here is correct or the figure that is stated in the tax return is correct.
Why didn't you check before today?
Wouldn't those documents have something that says, I certify that
Oh,
the above
yes.
information is correct? And is it not signed by her?
This one is not. It's an electronic filing.
Yeah.
So, we'd have to, this is something we've encountered before. We'd have to go and check who was the Kwinana and Associates representative for SARS purposes?
I would have to check and phone them and find out who was the representative at the time.
Could it have been you?
It could have been me, I don't know.
Indeed, because that's the person who declares chair. But let's leave the point. I see that Ms. Kwinana is not in a position to confirm for us today that her daughter made a misrepresentation in that email. How would your daughter have come to that 50 million figure?
I don't know, Chair. That's one of the things that I would have to audit.
I'm sure that that's something that...
Ms. Mbandra has got...
sorry.
Ms. Mbandra?
Question, but all the same, I'm a bit puzzled with this line of questioning. Insofar as the daughter is supposed to have misrepresented the tax returns, I just want to get confirmation that Ms. Hofmeyer is still working within the mandate of the Commission.
Yeah, surely she is. Yes, go ahead, Ms. Hofmeyer.
Thank you.
Thank you, Chair.
And just in terms of your earnings out of Kwinana and Associates for the period during which you did the joint business work, do you have any idea of how much you personally derived from Kwinana and Associates over that year? That's December 2014 to December 2015.
No, no, Chair, I don't have an idea.
We provided in your bundle all of your personal bank account records for this period because it was important for us to establish not only that Kwinana and Associates had derived benefit from this relationship, but also to give some quantification of the monies that came from Kwinana and Associates to you. And we calculated that at about 1.5 million for that period. Does that sound about right to you?
I also cannot confirm, Chair. I need to check.
Certainly. Well, if at any point you want to dispute that, you do have the records. You can do the painstaking calculation that we did. And certainly, Chair, I would invite Ms. Kwinana to give us a further submission if she thinks our calculation is wrong.
So where is that? Where is your
It's in your
calculation?
bundle, and it's just a series of bank statements from December 2014 to December 2015.
Oh, so it's in the bank statement.
Yes, okay. All right, now Nkonki. I'm so close to the end, I'm getting excited. Now, Nkonki, you also had a joint business relationship with, is that correct?
Yes, Chair.
And there, as I have it, between September of 2015 and July of 2016, there was work that you did together at Transnet and Eskom, and Kwinana and Associates was paid about 850,000. Does that accord with your recollection?
Yes, Chair.
Right. But there was also a particular payment that Nkonki made to Kwinana and Associates in August of 2015. Now, I just want to pause there for a moment. Remember, we looked at the 28 September 2015 board minutes a moment ago. Maybe I said that was an important day because a lot was happening on that day in the board. You were deciding to cancel the LSG Sky Chefs Award. You were cutting the CEO's delegation of authority, and we saw you were deciding to give the whole audit work, all of the audit work to Nkonki. Do you recall looking at those minutes a moment ago?
Yes, Chair.
Okay, so that's 28 September 2015. And a month before that, there's a payment that's made to Kwinana and Associates in a round figure of 300,000 Rand. Do you have any knowledge about that payment?
Yes, Chair. And in fact, that payment from Konki was going together with other payments from the other audit firms. What happened, there was a fundraising event where you would buy tables depending on the money that you want to buy the table, depending on the proximity of the person or the key person in the fundraising event. So that money from Konki was not the only money that we received. We also received monies from other audit firms. You may have seen the whole lot of other monies there. That was the fundraising event. So basically, the audit firms were buying the tables for the fundraising event.
What was the fundraising event?
The fundraising event was for the Jacob Zuma Foundation, who was the president at the time.
So you were doing fundraising as Kwinana and Associates for the Jacob Zuma Foundation?
No, Chair.
No, sorry.
The foundation was doing the fundraising. I was
You were donating.
no, Chair. I also, Kwinana and Associates also donated,
Yeah, that's what
and the other black audit firms also donated. So Jacob Zuma Foundation was doing a fundraising event, and the auditors were buying the tables. But now, because we do not have a consolidated bank account, and therefore it was decided by the Black Firms Forum. We called ourselves Black Firms Forum or Abasa Practitioners Forum. So it was decided that the money will be deposited, the monies will be deposited to me, and then I would pay the money to Jacob Zuma Foundation for the tables that we have purchased. So that was the reason for the money.
Thank you. I appreciate that explanation. It's different to the explanation that Ms. Masasa was able to get from the then CEO of Nkonki. But it's not, in fairness to you, Ms. Kwinana, it's not vastly different from yours. What troubled us about the explanation we got from Nkonki is that they said that it was a subscription fee that Nkonki was paying for the benefit of APF.
Yes, Chair, there was also a subscription fee. There was a subscription fee where all the firms were putting together. And then in addition to the subscription fee, there was also now the actual money for the tables.
Okay, I understand that, because we then investigated this whole APF and the fund, and we uncovered that there was no such fund at the time. What were you just using that term loosely?
Me?
Yes, when you said now that it was the APF, because we then went to the Abasa's Practitioners Fund and we found that they were deregistered before this payment was made. So was this some other arrangement that arose out of it?
I said the Black Firms Forum, which used to be APF before.
Yes.
Yes. So in fact, also the Black Firms Forum is not a registered name, so to say. You will not go to the CIPC and check the Black Firms Forum. That's how we call ourselves as the advocacy group of the Black Firms.
I understand. Thank you for that. Right. Then I would like to just go to two final small matters before concluding aspects, Ms. Kwinana. And these parts are going to be relevant to evidence that we traversed with Ms. Mieni. I understand from Ms. Mbanjwa that you may not have followed that closely, but it's actually related to matters that you were asked about in your Regulation 10.6 directive. The first one relates to the allegation, I'll put it broadly, that Ms. Mieni used to prepare false whistleblower reports. And you were asked in your 10.6 directive to tell the chairperson and the commission your knowledge about that. And let's take you to what you said, if we can. That is in your affidavit before the Commission in response to the 10.6 directive. So you need to go to DD 33. And it's page 5 of DD 33. Now, we asked in the 10.6 directive, the chairperson asked for you to address the allegations that Ms. Duduzile Mieni, I'm at the bottom of page 5, prepared false whistleblower reports against employees and management of SAA whom she wished to remove. And your response to that in your affidavit is, I have no way of knowing whether the whistleblower reports allegedly prepared by Ms. Mieni are false or not. Is that your evidence that you You don't know whether the report's allegedly prepared by her or false or not.
That's correct, Chair.
You see, Ms.
There is the question of knowing whether the reports she prepared were false or not. There is a question whether you have knowledge that she prepared certain reports. Which one of the two do you know? Which one do you not know?
I don't know any one of them, Chair.
Okay, all right.
You see, Ms. Nancy, do you know Ms. Pumeza Nancy?
Yes, Chair.
Did you follow her evidence before the commission?
Yes, Chair.
Okay, she said, and I'm just going to quote now from her affidavit, Chair, it's one paragraph, I don't think we need to go there, but for records, it's DD2, page 22, paragraph 71. If you want to go there, Ms. Kwinana, we will. But let me read it in, it's just her account. She said, oh, apologies, DD2 at page 22, paragraph 71. You see, we asked Ms. Nancy the same question, and in her affidavit, she said, Ms. Yakhe Kwinana will be the right person to address this, as she was the one who informed us about Ms. Mieni always going to the internet cafe, disguised as another person and sending damning whistleblower reports about anyone she wanted out of the way. After the whistleblowing report, she would pressurize Siyakhula Vilakazi, the internal chief audit and risk, to investigate those implicated in the report, or instruct him to appoint one of the firms, for example, EY or ENS, to investigate whoever was mentioned in the report. After all the investigation, she would push for those people to be suspended and dismissed. Now that is Ms. Nancy's account of something you told her. Do you confirm that you told her that?
No, Chair.
You don't. So is she just making this up?
She's making it up, Chair.
Do you remember saying the same thing at an interview with Auditor about 8 days after you resigned from SAA?
I remember having an interview, Chair, and I don't remember saying that Ms. Mieni did prepare false whistleblower reports.
What do you remember saying to them on this topic?
I would have to get the transcript, Chair.
Okay, but as you sit here now, can you just help me with your memory? What do you remember having said on this topic?
I remember, Chair, about the whistleblower reports. And basically, that's all I remember, that we used to receive a lot of whistleblower reports from the hotline or from Ms. Mieni herself. And she would basically get the whistleblower reports from the people. Other people would prefer to give her the information, basically.
So it was their information, and then they would give the whistleblower reports to her. Is that what your understanding was?
Yes, Chair.
Okay. That would tend to indicate that there was nothing false. That explanation is there's a genuine whistleblower. They've got their facts, but for some reason they want to give them to Ms. Mieni rather than put them through the anonymous system that was created, correct?
Yes, Chair.
Okay. So in that scenario, there wouldn't be any reason to suspect them being false. Do you accept that?
Yes, Chair.
Or
That's why, Chair, I'm saying I have no knowledge if the whistleblower reports were true or false.
And is that what you recall having conveyed to Auditor at that meeting?
Yes, Chair.
Yes. Now that meeting, as I understand it, was you had requested to meet with Auditor. Is that right?
Yes, Chair.
And then there was a second meeting that was a follow-up meeting, correct?
Yes, Chair.
Why did you request to meet with Outer?
The reason why I wanted to meet with Outer is because they wanted to make an application for me, for also myself to be declared a delinquent director. So the reason why I went to them, in fact, I was advised by one of my lawyer friends to say, I need to go to them so that I can clear the things that they may have against me. And in fact, I managed to clear the whole lot of wrong information that they had against me. So it was a good thing that I did go and clear it to them. And in fact, I told them that the reason why I'm going to them is not because I will be declared a delinquent director. The reason why I am going there is that, of course, I would have to protect myself legally. But the reason why I am going to Outer is because I will not have money to incur the legal costs to get to the end result, which end result I know that I am not going to be declared a delinquent director. That was the reason why I went there.
I understand. Now, Ms. Kwinana, we previously had evidence admitted on affidavit in Ms. Nansi's case when she gave evidence from Outer. And Outer confirmed that you'd met with them, and everything you've said now is consistent, that you'd called for the first meeting, that there was a follow-up meeting. But they had long recordings from the meeting, and but then they had a summary, their own summary of it, in which their summary records that you told them something very different to what you've testified about today. They said at that meeting you told them that Ms. Mieni used to put in false whistleblower reports. Does that not jog your memory?
I'm sure they misunderstood me, Chair. Maybe I wanted to say something, but now because I said it in English, then it lost the meaning because I speak Xhosa fluently.
Right. So you, as you sit here today, you can confidently say you did not convey to them that Ms. Mieni would put false information, incorrect information in whistleblower reports that she prepared, correct?
Correct, Chair.
Right. You see, I am sometimes able to anticipate what, based on what you've told us in our investigations, is likely to be the approach you take in the evidence. On this one, I thought you might say something like that. So what we did is we went and got the recordings from Outer, and we had them transcribed. So I'd like to hand up those transcriptions. We didn't have them previously, and I have to tell you, I'm going to ask you about two aspects of that Outer interview, and I can tell you, Chair, we've managed in the time available to transcribe one, but not the other. We do have the recording of the other, but all I can show Ms. Kwinana today is the transcription of the one dealing with whistleblowers. So if I can hand that in, and copies certainly also to Ms. Mbanjwa. I do apologize for that error earlier. Thank you. Oh, sorry. Oh, have I given you the wrong one? Sorry. There you go. Chair, if I can request that we enter this as Exhibit DD33A. No, there's no A. I've made that error, sorry. DD33.26.
Did you say 53?
No, 33.
33.
Yes, thank goodness we're not at file 53.
33?
Yes, point 26.
26. the transcript of a meeting with Ms. Yakhe Kwinana at Outer Offices, Johannesburg, 30 August 2016, will be admitted and as Exhibit DD 83.26.
So it's a very lengthy recording. What we did was we extracted that part that dealt with the whistleblower discussion. And if you turn to page 3 of 10, you'll see that that is where it is. Internal page 3 of 10 at the bottom. Do you have that, Ms. Kwinana?
Yes, Chair.
Okay, so this is the section of the whistleblower discussion. And Ivan starts speaking, and then Ms. Kwinana, and then there's another person identified as Retabile. And what happens is, this is where the topic of the whistleblower discussion is being introduced. And there's an issue that occurs where people are talking about them feeling a bit scared, actually. And if you go over the page to page 4 of 10, you'll see that Ivan says in the 4th line, I have received death threats. I have received death threats. And then, Ms. Kwinana, you say the following. One of the reasons why I am scared is that I do not know the powers that be beyond. But the other reason is that it's difficult to bring a proof. Like, for instance, Dudu has got her hit list of people that she wants to remove and bring her own people. What we've got that, and how she operates. How she operates, she will go to Internet Cafe and write whatever information that she knows are correct and incorrect information. And then she will email it to SAA Whistleblower from the Internet Cafe. And then Ivan says, which information? And you say, like for instance, she will write, okay, let me make an example. She will go to the Internet Cafe and type whatever she knows about me. She will add the correct information together with the incorrect information. And then now, okay, if I'm an SAA employee, she will send that to Whistleblower. That's how she operates. She will send that to Whistleblower. And after sending it to Whistleblower, it will go through the process. Ms. Kwinana, that I put to you is very different to what you said just now, is what you conveyed to Outer. Do you accept that it is very different?
It's very different, Chair.
Do you have any reason to dispute this transcript?
Chair, this transcript, I see that it is edited.
Yes.
And I was not taking the minutes myself. And therefore, I will definitely not be able to confirm with certainty if this is what was discussed. But what I am saying is, I will not be in a position, as I said before, I will not be in a position to know if the whistleblowers are true or false.
No, but that's not what you, sorry.
Yeah, let's start here. You have accepted that what you have said about what you know with regard to Ms. Mieni's connection with whistleblowers reports is different from what is said here. Which one is true? Is it what you said earlier on here, or is it what is reflected here? Which one is true?
This is what I said earlier on here, Chair.
That is what is true.
Yes, Chair.
Are you saying that you never said what is reflected here when you met with Outer?
I may have said it, Chair, not wanting to convey the message as it is. As I was saying, maybe if I was interviewed by Outer in Xhosa, I would be in a position to articulate myself and reflect what I have just said in this commission today.
No, Ms. Kwinana, please. I've listened to you speaking English on Monday, Tuesday, and today. You speak English very well. I understand what you are saying. I don't have a problem. I think Ms. Hoffmeyer understands you. We understand you, and when we speak to you, you understand us. It can't be a question of language. It can't be.
Chair, it could be a question of language. Also in this commission, Ms. Hoffmeyer has been asking, including you, Chair, many times, if I heard Ms. Hoffmeyer, if I understood what she was trying to say. You have been explaining, Chair, the whole lot of times.
Yes, but I don't think it's been because of the language. It has not been because of the language. Your command of English is very good. Your understanding of English when somebody else is speaking English is very good.
Chair, between this recording, outer recording, and what I have just said in this commission, I stand by what I have said in this commission.
Well, then, sorry.
Yeah, no, that's
No,
fine.
then I'd like to put it to you that you went to Outer with an intention to try and avoid being one of the defendants in the delinquent director application that they were considering bringing, and then said something false to them about Ms. Mieni to try and put yourself in a good light to avoid that. What's your response?
I don't think the reason for me to be excluded in the application is because of the whistleblowers.
No,
It's because of the clarification of the incorrect things that they had about me. Like, for instance, one of them was BNP Capital, where they were thinking that I knew who the directors of BNP Capital, because the director of BNP Capital is a co-director in another company with my cousin brother.
Yeah,
So
Ms.
basically, those are the things that they had misinformation about. I don't think their reason for them to exclude me is because of my lack of English.
No, Ms. Kwinana, that is not what I was saying at all. I'm not actually asking you about their reason. You could never know their reason. I'm asking about what you went there to achieve. Because what has been revealed now is that there's a transcript of a meeting that you had with Outer 8 days after you left SAA, in which you on 2 occasions make it very clear that what Ms. Mieni was including in these whistleblower reports was, quote, incorrect information. You say in your evidence today that is false, that you did not say that, and that you have not ever, I understand your evidence to be, had that knowledge that she was doing things and putting false information in whistleblower reports. But if that is the truth, then I put it to you, your motivation for then making up what is false, a lie, served your interests, because it put you as an adversary to her, painted her in a worse light, so that you could escape being one of the defendants in the delinquent director application. If that's not it, Ms. Kwinana, how else do you explain, if this is accurate, the lie that lies here? You were then lying that she used incorrect information in the whistleblower reports.
Let me respond, Chair, for the last time. I am saying this document, you have just confirmed that it is edited. That is number 1. And number 2, you have asked me that between what I have said here and what is in this document, which statement do I stand for? I am saying, Chair, for the last time, I am standing by the information that I have said in this commission.
If it were to be found that you did actually say what is reflected here, would you agree that then, if what you have told us is true, namely that you don't know whether Ms. Mieni was involved in preparing false reports, would you then accept that then you were untruthful when you spoke to Auditor, if it were to be found that you did say this?
Chair, you know, firstly, I wasn't even informed that I am recorded. And secondly, here, I am speaking under oath. There was no oath here, Chair. And therefore, when you say between what I am saying here today and what is stated here, I am saying, Chair, I stand by what we have heard here before.
Yes, but that doesn't answer my question. The fact that you may not have been speaking under oath at outer offices can't change whether what you said is true or not, isn't it? Even if, in other words, something doesn't become true only because you are under oath. When you are not under oath, you can tell something that can be untruthful or you can be truthful. Now, my question to you was, if it were to be found that you did say this at outer as reflected here, but now you are saying that's not true. What is true is that you don't know anything about Ms. Mieni making false whistleblower reports. Would you accept that you were therefore untruthful when you said this to Auditor, if it is found that you did say this?
Chair, this Auditor report, as I said, it is edited. That's number one. Number two, Chair, this report, I was never informed that I am being recorded. And thirdly, Chair, I was never informed that this report will be used against me in any forum. And therefore, Chair, I do not recognize this report.
I've asked you the same question 2 times, and each time you have not answered the question. I'm going to ask it for the 3rd time and the last time, and see whether you are going to give me an answer. The question is, if it were to be found that you did say what is reflected in this report, and now given the evidence you have now given here, would you accept that, therefore, it would mean that you were untruthful in what you said to Auditor about Ms. Mieni?
Chair, I beg not to answer that question.
You don't have a right not to answer that question, Ms. Kwinana, but we are going to move ahead. This doesn't do you any good, Ms. Kwinana. It doesn't do you any good. Continue, Ms. Hofmeyr.
Thank you. Chair, I really don't want to take more time. If we had time, I'd suggest that we play the recording, but I'm not going to suggest we do that now.
Yes.
It's late, we've been here the whole day. What I want to propose is that we give Ms. Kwinana the recording, and she listens to it, she gets her own transcriber, and if there's any part of this transcript that she says is inaccurate, she could let us know.
Yeah, she can do a supplement,
Indeed.
an affidavit.
Indeed,
Yeah.
because when transcribers say edited at the top, It means they've gone through and they've changed scarred, which appeared with 2 R's, into scared. They're editing it for ensuring that they're not typographical errors. They're not editing to change the
Substance.
task, which is to have an accurate reflection of the document. But I can see Ms. Kwinana is not comfortable relying on this, so we'll make the recording available to her, and she can let us know in a supplementary affidavit if she disputes the transcript that has become Exhibit DD 33.26. The last aspect of your interview there, Ms. Kwinana, is what you had said about Talente Mieni, Duduzile Mieni's son, in his involvement in BNP. Do you remember what you told Auditor was Mr. Mieni's involvement in BNP?
No, Chair, I don't remember.
Okay, because your affidavit before the commission, let me just deal with that. Give me a moment if I can get it. It's at page 6 of Exhibit DD 33. You were asked again about the allegations that Ms. Mieni's son, Mr. Talente Mieni, was in a relationship with Mr. Masocha Ngadi. Mr. Masocha Ngadi was the person who was involved in BNP. Did you know that Mr. Ngadi was involved in BNP?
Yes, Chair.
Okay. So the question was, what do you know about the allegations that Talente Mieni had a relationship with Mr. Masocha Ngadi? And your answer there on affidavit was, I have no knowledge of the alleged relationship between Mr. Mieni and Mr. Ngadi. So did you not tell Auditor anything about that relationship?
I don't remember, Chair.
Okay, so you could have.
I don't know. I really do not know. I don't know what is it that I would have told Auditor, because I really do not know.
Do you remember telling them that you had seen Mr. Talente Mieni and Mr. Masocha Ngadi together at SAA?
Definitely no.
Do you remember telling them that they are likely, that they're associates, business partners?
No, I don't know that.
Do you remember telling them that you had seen them in Sandton together?
No.
Okay, that is what appears in the recording of the meeting with Auditor. We didn't get it transcribed. There was insufficient time. We've got the recording. We'll provide it to Ms. Kwinana, and she can tell us why today she confirms under oath that she didn't say those things, whereas the recording indicates that she did. Chair, I would then like to just go to the conclusory aspects, if I may, unless there's something further. Ms. Kwinana, we will likely make submissions in due course to the chairperson that seek to summarize the effect and content of your evidence over the last 3 days. And this is the opportunity where I indicate to you what the submissions are likely to be, and you have an opportunity to respond. So these...
Maybe before you do that, Ms. Hofmeyer, I'm sorry, maybe I should just deal with this one thing which continues to be a matter of concern to me with regard to Ms. Kwinana's evidence. That's about that agreement, Ms. Kwinana, between Slipknot and Ms. Memela, and the fact that you gave a wrong address there. I heard you say something like maybe the reason why you put a wrong address was that you did not understand Domicilium. Is that correct?
Yes, Chair. Plus the fact that we have been there for many years, and therefore basically that's what would come to my mind.
You don't mean that between 2013 and 2015, whenever you were required to write your business address, you would have written 92 President Park. That's not what you mean. Do you? Is it what you mean? If we go and check all documents between the time when you vacated 92 President Park and 21 April 2015, are we going to find that whenever you were required to put in your business address or slip notes address, this is the address you put all the time?
Maybe, Chair.
Maybe.
Yes,
You think you may have done that?
I may have done that, Chair.
But in that case, it wouldn't have been about domicilium, would it have been?
It would be the business address. It would be the business address, Chair.
It would have been the business?
It would be the business address.
Yes, but your business would not have been operating from that address for quite some time, isn't it?
Yes, Chair, but as I said, I have been there for a long time. Hence, I haven't even forgotten the business address as it is now, including its postal address.
So you think you would have forgotten the most recent address or the current address where Slipknot was operating from, and you remembered an old address? That can't be.
It's possible, Chair, because in 2015, I think the offices of Kwinana and Associates, were in Linwood, and Slipknot Investments, the address that we had been using for Slipknot Investments is the old address.
Well, when Mr. Nzeg was giving evidence, and he had initially, I think, said that the agreement between himself and Ms. Memela's mother had been entered into in 2015. Once certain things were pointed out to him by Ms. Hofmeyer, he considered that that agreement could not have been concluded in 2015. As I recall, he
Indeed.
considered that it was concluded in 2019. Are you going to concede that this agreement could not have been concluded in 2015, Ms. Kwinana?
The agreement, Chair, was
This one?
It was concluded in 2015, Chair.
Okay. Ms. Hofmeyer?
Thank you. Ms. Kwinana, so I'm going to put the propositions to you to give you an opportunity to respond. We will likely make submissions in due course that while you served at the board of SAA, particularly during the period late 2014, 2015, you created a climate of fear and intimidation in SAA against those who opposed you. Do you dispute that?
I dispute it, Chair.
You accused those who stood in the way of the unlawful 30% set-aside policy of insubordination and treason. Do you dispute that?
Sorry, what's your question, Chair?
You accused those who stood in the way of the unlawful 30% set-aside policy of insubordination and treason.
That's not correct, Chair.
You unfairly favored AAR and JM Aviation in the components tender. Do you dispute that?
I dispute it, Chair.
You awarded a tender to them worth more than 1 billion rand when they should have been disqualified in that tender. Do you accept that?
I dispute it, Chair.
You got payments for favouring them in this way to the tune of 4.3 million. Do you dispute that?
I dispute it, Chair.
You received, you have made up a story that is clearly false, involving confidentiality policies and hand-delivered statements in order to try and legitimize the benefits that you received for favouring AAR and JM Aviation in this way. Do you dispute that?
I dispute it, Chair.
And you helped Ms. Mamela to hide the fact that she also got a benefit from this because of the way in which she'd assisted JM Aviation. Do you dispute that?
I dispute it, Chair.
We will also argue in due course that you've been a dishonest witness, Ms. Kwinana. Do you have a response to that?
I also dispute that, Chair.
And finally, that as an accountant, you auditor, you benefited personally from payments that the joint auditors of SAA made through business relationships with you, your company, while they were auditing SAA and while you were making decisions to keep appointing them without going through a tender process. Do you dispute that?
I dispute it, Chair.
Thank you, Chair. Those are our final questions.
Thank you very much. Ms. Mbandwa, I'm grateful to you that you came up with the proposal that you came up with in terms of no re-examination, but you submitting something. I think it's helpful, particularly because we have finished much later than we thought we would.
Indeed.
Yes. But Ms. Kwinana, thank you very much for coming to give evidence. And thank you for your cooperation, both you and Ms. Mbandwa, in terms of assisting the Commission to sit even on a Saturday to try and finish its work, because there isn't much time left. Thank you very much to Ms. Hofmeyer and her team for all the hard work and making yourselves available even on a Saturday. Thank you very much. We are going to adjourn. Or next week I will be hearing evidence relating to Danielle. That is just for the information of the public.
Apologies, Chair. I just wondered the timelines about those submissions on re-examination. Is it in order if we submit them on or before the end of November?
Yeah, that would be fine.
Thank you.
That will be fine. Thank you.
Thank
we
you,
adjourn.
Chair.
All rise.